lives and the gift of today. Thank you for giving us a bright new day and a day of freshness. We started this program in your name and by your grace. For all these days, you've preserved and protected all of us, more especially our guests from various places. Thank you for the exciting times that this entire exercise has witnessed. And we bless your name for this day where we're going to have the finals for this entire program. We pray your presence to be with us. We are commending all our contestants before you, various teams, as well as all our judges, that there will be fairness, there will be freeness in everything we come to do here, and that at the end of it, we'll have cause to praise you for what you have done. Glory and honor be to you for hearing our prayers, because you have asked for this and many more blessings through Christ Jesus our Lord. Amen. Thank you. Please sit.
Well, out of about 63 teams, was it up to 63? We're down to 4. And if I can recollect well, we have teams 23, team 11, we have team 15, and team 16. Team 6, all right. They're here, poised for action. So without much ado, I'd like to invite Mr. Lloyd Kubaya, the Deputy Director for the Center of Human Rights, to introduce our judges for this morning's finale. Give him a round of applause.
A very good morning to you all protocols observed, and welcome to the final of the 32nd edition of the Christof Heyns African Human Rights Moot competition. I'm just going to introduce the judges so that we know who they are, and then I'm going to hand over to the president of the court to take us through and be in charge of the proceedings for the next 2.5 hours. On my immediate left, we have Advocate Claudio Fokiko. He is from Mozambique. He is a lawyer. He's running a law firm in Mozambique. He's also the Vice President of the National Human Rights Commission in Mozambique through the Bar Association of Mozambique. Next to him is Judge Dr. Sylvain Ore. He is a lawyer. He also teaches international human rights law, and is also the former president of the African Court on Human and People's Rights. His tenure ended in 2021, and he's from Ivory Coast, Côte d'Ivoire. I'm going to skip the presiding judge, whom I'll introduce last. Next to him is Dr. Wilson Almeida Adao. He is from Angola. He is also a lawyer, but he also teaches international human rights law at the Catholic University. And he is also the director of the Center for Human Rights at the same university in Angola. Next to him is Professor Laurence Begog Larsen. Forgive my French. She's a professor of law at the Sorbonne Law School in Paris, France, and she was also a judge of the Constitutional Court of Andorra, and she was the court's president from 20 2014 to 2016. She also enjoys teaching international human rights law. Mainly, she told me that she loves comparing the African human rights system, the inter-American system, and the European regional system of human rights. So she combines all the regions, and it will be interesting to see how she's going to interact with the advocates before us this morning. And then finally, we have Justice Dr. Ernest Owusu-Dapa. He's a lawyer. He is also taught international human rights law. He has a law practice here in Kumasi. He is the former dean of the Faculty of Law of KNUST. And currently, he is a judge of the Court of Appeal here in Ghana, based in Accra. He has been involved in the Moot for a very long time, so he understands a lot of what happens in the Moots and how the proceedings happen, particularly the preliminary rounds as well as the final. So this is your bench this morning, very eminent judges who understand international human rights law, who practice it, who have taught it, and who have presided. Some of them, I think 3 of them have presided in the courts. I also just want to mention that in terms of experience at the regional level, because I think the hypothetical case includes an aspect on children's rights, that Dr. Adao, also not Adao, is also a member of the African Committee of Experts on the rights and welfare of children. So we are going to be interacting with somebody who is at the center of protection of children's rights at the African regional level. So this is the eminent panel of judges that are presiding today. I wish you all the best. I will now hand over to the presiding judge, Justice Dr. Ernest Owusu-Dapa. I just wanted to also to ask either Marty or Syed, if they're in here, to hand over a copy of the hypothetical case to the presiding judge. I think it's not on before him. If we can hand it over to him now as I hand over to him. Thank you so much, presiding judge. Over to you.
Thank you very much, Deputy Director Lloyd, for Center for Human Rights Metro Victoria, the main organization behind this. Good morning to all of you. Justice Gertrude Araba Isaba Saki Tokonu, the Honorable Chief Justice, who was originally supposed to have presided over this final competition, but due to prior commitments overseas, she is not here, and I have been appointed to hold brief for her in this final competition. So at the end of the competition, we extend some few words she would like you to hear as future lawyers and law students when we are giving our comments. So I will call the bailiff to call the case before the court.
All right. The African Court on Human and People's Rights is now in session.
in the matter between Ozanga Human Rights Association and the State of Sentivia. The Honorable Judge, Justice Dr. Ernest Owusu-Dampah, presiding.
You get the invitation gadgets.
Tous se lèvent. La Cour africaine des droits de l'homme et des peuples est en session dans l'affaire entre Association des droits de l'homme de Gozanga et État de Saint-Sylvia. Le honorable juge, M. Owusu-Dampah, préside.
So before we start, we'd like to get the time and location by both parties. So if you put it down, you can share with us. Or we take it that they're speaking for 10 minutes each. So applicants, what reservation have you made for rebuttal so that we take note of that before we continue? So the rules we understand are that each side will be given 1 hour to present your case. So as applicant, you will have to tell us what portion of the 1 hour you reserve for rebuttal. Shall we have a presentation for the applicant?
President Judge, Your Excellencies, good morning. My name is Japit Ntikia, first agent for the applicant, the Gozanga Human Rights Association. Appearing alongside me,
Mame Amal Anand, second agent for the applicant.
Ajubi Kitibando, third agent for the applicant.
Trevor Kamau, counsel for the applicant.
Your Excellencies, today this honorable court much obliged, Your Excellency, we reserve 3 minutes for rebuttals. Yes. 12 minutes. Much obliged, President Judge. Today, this honorable court is faced with a question of a republic that has and continues to condone acts of illegal mining, corruption, which has resulted in the diminishing of public resources, depletion of the environment, the exhaustion of public funds which would have been used to curb a public pandemic, and inadequacy of funds to sustain education policies. I will take 12 minutes of this court's time to demonstrate that this honorable court has jurisdiction to entertain the matters before it. The structure of my argument
is as follows. First, I will demonstrate before you, Your Excellencies, that this court has material jurisdiction. Second, I will demonstrate before you that this honorable court has territorial jurisdiction. I will also endeavor to demonstrate before you that this honorable court has personal jurisdiction. Lastly, Your Excellencies, I will demonstrate to you that this honorable court has personal jurisdiction to entertain the matter before it. Every application that comes before this honorable court, the court has a mandatory obligation to conduct a preliminary examination of its jurisdiction, whether contested or not. This was the holding of this honorable court in Wanjara versus the State Republic of Tanzania in 2020 Africa Law Report. In Miriam Kauma versus Temali, this honorable court held that it must satisfy itself that it has material jurisdiction, temporal jurisdiction, personal jurisdiction, and territorial jurisdiction. On material jurisdiction, the rule is found in Article 3, Sub-Article 1 of the court's protocol establishing this honorable court, which provides that this honorable court has the jurisdiction to entertain matters that relate to the interpretation and the application of the African Charter, the court's protocol, and any other relevant human rights instruments.
Agent, we've had the benefit of the memorial by the respondent. I've heard mentions of jurisdiction. Is there any aspect of jurisdiction which is contested by the respondent?
Much obliged, Your Excellencies. In the case that the respondent do not contest material jurisdiction, it is still the obligation of this honorable court to conduct the preliminary examination of its jurisdiction. On material jurisdiction, Your Excellency, reverting to my arguments, this court has the duty to conduct a preliminary examination which seeks to determine whether the matters relate to the application, the interpretation of the African Charter on Human and People's Rights, the court's protocol, and any other relevant human rights instrument. In the instant case, the Ngozanga Human Rights Association brings before you issues of human rights violation, which are catered for by the various relevant human rights instruments ratified by the state of St. Sphere. On territorial jurisdiction, the rule is that this honorable court must determine whether the matters which are brought before it happened before the deposition of the optional declaration under Article 34, Sub-Article 6 of the court's protocol. Your Excellencies, a keen interrogation of the facts will bring to the fore the fact that the Ngozanga, the matter relating to the Gohara members and the children, the FSH policy, and the Center for Sexual Minority Rights occurred after the ratification or the deposition of the optional declaration in 2017, Your Excellencies. It is therefore not in contention. Admittedly,
But
however,
Agent, we are told that the Supreme Court of the respondent state has ruled that it is a dualist country. So having merely signed and made the position, if it has not been domesticated into the municipal law of the respondent state, will this court still have jurisdiction?
Much obliged, Your Excellency, for a very valid question. Article 3, sub-article 1, provides that this honorable court has to determine whether it has jurisdiction based on the African Charter and the court's protocol. However, Your Excellency, in Ernest Mtungwi versus Tanzania, this honorable court held that it has to determine whether the decision by the domestic courts have met the international master or the international standards. It is also our submission to you that according to the Vienna Convention on the Law of Treaties, courts, domestic courts and states cannot rely on domestic decision or laws to override the application of international law. Your Excellencies, on personal jurisdiction, it is our submission that the rule is that the state must have deposited the optional declaration and the NGO must have observer status before the African Commission. It is our submission to you that the Gozanga Human Rights Association has gained observer status in 2015. The state of St. Sphere has made the optional declaration in 2017. It is therefore our submission to you that this honorable court has personal jurisdiction to entertain the matters before it. On territorial jurisdiction, the rule is that all matters that occur within the territory of the state, this honorable court has jurisdiction to entertain. In the decision of Isa Konate versus Burkina Faso, in the year 2014, African law reports, this honorable court held that it had territorial jurisdiction for the matters or the issues brought therein involved matters that occurred within the territory of Burkina Faso. Your Excellency.
And one of the matters before the courts, the trial took place in the Republic of Camelot, and the Camelot government granted pardon. And Camelot is not a party in this matter. Can this court still proceed and entertain that particular issue relating to the trial and the pardon?
Much obliged, Your Excellency. The actual offense of illegal mining occurred in the state of St. Sphere. That therefore does not exclude this honorable court from determining the violation of human rights for the matters or the issues occurred within the territory of the State Republic of St. Sphere in the eastern region of Akan. Lastly, Your Excellency, it is on temporal jurisdiction. The rule is that this honorable court has to determine whether matters occurred after or before the deposition of the optional declaration under Article 34, Sub-Article 6 of the court's protocol. Your Excellencies, it is our submission to you that the matters that involve the FSH policy, as is borne out of the fact, matters involving the violation of the right of the Gohara staff members and the children, the matters involving the Center for Minority Rights, occurred after the ratification of the optional declaration. Admittedly, however, the issue on corruption of Ms. Tanzana Adongo and the effects of the illegal mining occurred in 2018 before the ratification of the KNUST Protocol in 2019. We, however, submit to you that this Honorable Court in Kijiji Isiaga versus Tanzania held that it has jurisdiction to entertain continuous matter. Continuous matters, Your Excellencies, are matters that continue to subsist after the ratification of the optional declaration. As is borne out of the facts, it is evident that the effects of the illegal mining, the corruption of Mr. Nzana Adongo, are still felt up to date in the state of St. Sphere. Your Excellencies, having come to the conclusion of my arguments, it is our prayer before this Honorable Court that it finds it has jurisdiction to entertain all the 4 issues brought before it. If I am of no more help to this Honorable Court, I now yield the stage to the second counsel of the applicants to further our submissions.
Admissibility.
Much obliged, Your Excellency. Indeed, the second counsel, learned counsel Ama, will address admissibility.
Any question? Yes.
Yes, thank you. Advocate for the applicant. You said that corruption is not a continuous matter. Are you talking about continuous matter or continuous violation?
Much obliged, Your Excellency. Our submission before this Honorable Court is that the effects of corruption perpetrated by Mr. Nzana Adongo continue to have a violation effect to the citizens of the State Republic of St. Sphere. Much obliged, Your Excellency, hoping that I have satisfied that question, I now yield the stage to the second counsel of the applicants to further our submission. Much obliged, Your Excellency, for that very important question. Continuous violation are violations that before the ratification, its effect or subsistence are continuous in nature. In other words, Your Excellency, simply put, that the effects of the violation might have occurred before, but its effects are continuous or subsistent in the State Republic.
Right. Point noted. So yield to your colleague.
Much obliged, President Judge.
Mr. President, Your Excellencies, may it please the court, Mame Ama Anan, appearing as second counsel for the applicant, Gonzaga Human Rights Association. Within the next 15 minutes, I would be addressing this court on the preliminary issue of admissibility, as well as a first substantive issue regarding Sentifia's failure to hold Mr. Putinyango accountable for illegal mining and Mr. Insana Adongo accountable for corruption. With Your Excellency's permission, I would begin. On the preliminary issue of admissibility, the applicant submits that the instant application is admissible. Your Excellencies, Article 6.2 of the Court's protocol mandates the court to rule on the admissibility of cases having due regard to Article 56 of the African Charter. Your Excellencies, Article 56 makes provision for 7 admissibility conditions. However, in this present matter, the requirement to exhaust local remedies under Article 56(5) of the African Charter appears to be in contention. On this, the applicant presents 2 submissions. First, that local remedies have been exhausted in the cases of the illegal mining and the CSMR. And second, that the requirement to exhaust local remedies should be waived in the cases concerning dishonest corruption, the treatment of the children and girl senior members, as well as the FSH's policy. On our first submission, regarding the exhaustion of local remedies in the cases of the illegal mining and the CSMR. Your Excellencies, the applicant submits that these cases are admissible because from paragraphs 14 and 26 of the facts, these matters were pursued up to the Supreme Court in Sentifia, which is the final appellate court as seen from paragraph 6 of the facts. On our second submission, regarding the waiver of the requirement to exhaust local remedies in the cases concerning dishonest corruption, the treatment of the children and girl senior members, as well as the FSH's policy. Your Excellencies, on this, the applicant submits or that argues that the requirement should be waived because local remedies are unavailable, ineffective, and unduly prolonged. Your Excellencies. Yes, Your Excellencies. Your Excellencies, in accordance with Article 56(5) of the African Charter and also the African Commission decision in Jawara versus the Gambia, decided in 2000, the requirement to exhaust local remedies would be inapplicable where the remedies in the respondent states are unavailable, ineffective, insufficient, and where they are unduly prolonged. Your Excellencies, in the matter concerning Mr. Insana's corruption, the applicant argues that local remedies are unavailable. Your Excellencies, a remedy is available if it exists and can be pursued without impediments. This was noted by the court in Norbert Zongo and others versus Burkina Faso, 2014, One African Court Law Report, page 219 at paragraph 109. Your Excellencies, a recourse to Section 5 of the OSP Act in Annex 1 of the fact reveals that the OSP is a body mandated to investigate and prosecute corruption allegations. Your Excellencies, this is a discretion vested in the OSP. In effect, private persons such as the applicant cannot have a cause of action in matters of corruption. Your Excellencies, it is on this basis that we submit that local remedies are unavailable to the applicant and humbly implore the court to waive the requirement to exhaust them. Concerning the FSH's policy, Your Excellencies, on this matter, the applicant also argues that local remedies are unavailable If I may direct this court to paragraph 6 of the facts, it reveals that only citizens can challenge the decision of a public body. Your Excellencies, in this present matter, the applicant is a juridical person and not a citizen, as seen from paragraph 8 of the facts. As such, it does not have the capacity to challenge the limitation of the FSHS policy.
Is it your argument that juridical persons cannot have nationality of the respondent state?
Your Excellencies, our argument before this court is that under Scientific law, the concept of nationality is conferred to natural persons as well as juridical persons, such as the applicant. However, in order to challenge the limitation of the FSHS policy, the applicant must be a citizen. And in this present matter, considering that the applicant is an artificial person, it does not have the capacity to institute any action within the respondent state. Your Excellencies, from paragraph 6 of the fact, it reveals that all citizens can challenge the constitutionality of a legislation or an action of a public body. And given that the decision was taken by the government to limit the FSHS policy to only 150 less endowed schools, which has resulted in a violation, the applicant cannot have a remedy within the respondent states, but only has a recourse of action before this honorable court. And that is why we are before this court, urging the court to admit the matter and determine the merits of the case. Your Excellencies, proceeding to the argument on the treatment of the children and GORES senior members. The applicant argues that local remedies are ineffective. Your Excellencies, a remedy is effective if it offers a prospect of success. And this was noted by the African Commission in Jawara versus the Gambia, 2000, African Human Rights Law Report, page 107 at paragraph 32. If I may direct this court...
May I? Can you appoint some case of African court regarding these issues?
Your Excellencies.
Can you appoint one case of African court regarding the issue of local remedy rules?
Yes, Your Excellencies.
Thank
Your
you.
Excellencies, in the case of African Commission versus Kenya, decided in 2017, the court noted that where the local remedies are unavailable or do not meet the criteria of availability, effectiveness, and sufficiency, then the requirement to exhaust remedies would be waived.
The commission and decision of the court on the matter, which of these two decisions should this court be persuaded by?
Your Excellencies, this court should be persuaded by its own decisions. Though its decisions are not binding by it, we urge this court to draw inspiration from its own decisions. Reverting to my submissions, Your Excellencies, if I may direct you to paragraphs 14 and 26 of the facts, Your Excellencies, we would notice the state's alacrity in determining the appeals pertaining to the illegal mining and the CSLR. But sadly, comparing those cases to the present matter, the respondent state has adopted an adverse posture in determining GORES appeal. Your Excellencies, from July 2021 up until May 2023, 23 months have elapsed, and yet no date has been set for hearing GORES appeal. Yes, Your Excellency. Your Excellencies, we do acknowledge that the 2 years has not been exhausted. However, it is our submission that this unwarranted delay to set a hearing date is discriminatory. Your Excellencies, on one hand, the Court of Appeal has gone ahead to expeditiously determine other matters, such as the illegal mining and the CSMR, as can be seen from paragraphs 14 and 26 of the facts. However, concerning Gore's appeal, the Court of Appeal has not even set a hearing date, and it has been 23 months. And it is for this reason that we submit before this court that the delay is indicative of undue prolongation and has consequently curtailed the applicant's right to remedy. Your Excellencies, on this basis,
And just as we render a decision, the Court of Appeal sets a hearing date and it also comes out with a judgment. And where there is this discrepancy between the judgment of the Municipal Court of Appeal and the African Court, how will the respondent state be guided?
Your Excellencies, I do understand your concern. However, it is our argument before this court that the respondent state has adopted an adverse posture in determining Gore's appeal. And as such, the likelihood of the courts pronouncing on the matter is very low. It is for this reason that we humbly implore this court to admit the matter for determination. Your Excellencies, the applicant is in a state of limbo. On one hand, lies a judiciary given enough signs that it cannot grant the applicants the remedy they deserve. On the other hand, it's a jurisdictional impasse, given the same applicants a denial of access to the very courts they are supposed to turn to. Your Excellencies, it is on these grounds that we urge this court to waive the requirement to exhaust local remedies in the cases concerning dishonest corruption, the treatment of the children and Gore's senior members, as well as the FSH's policy, and determine the matter based on its merits. Proceeding to our first substantive issue regarding Scientifia's failure to hold Mr. Puti Yengo accountable for illegal mining and Mr. Insana Adogo accountable for corruption. Your Excellencies, on this, the applicant submits that the respondent state has violated the African Charter and other human rights norms because, first, the state failed to hold Mr. Puti Yengo accountable for the illegal mining and consequently violated the victim's right to reparations. Second, Your Excellencies, the state failed to take any remedial measures to rehabilitate the decimated environment and have therefore breached their obligations to protect the environment. Your Excellencies, on our first submission regarding the state's failure to hold Mr. Putin accountable. Your Excellencies, a state in whose territory a violation occurs bears the sole duty to prosecute. This was noted by the African Commission in Zimbabwean NGO Forum versus Zimbabwe, 2006, African Human Rights Law Report, page 128 at paragraph 146. Your Excellencies, this duty of the state to prosecute cannot be delegated unless warranted by necessity. For this position, we refer the court to the International Law Commission 2014 report on the duty to prosecute or extradite. Your Excellencies,
just as we witnessed in the instant case with Camelot, and prosecution takes place in the other state with which respondency has extradition, would that not suffice to discharge the obligation of the respondent state to prosecute?
Your Excellencies, we do understand your concern. It is, however, our submission that the extradition arrangement, as seen from paragraph 13 of the facts, in the first place, was unnecessary and constituted an unjustified entrustment of the state's duty to hold Mr. Putin accountable. Your Excellencies, as a result of this unjustified entrustment of the state's duty, a brazen impunity has occurred since Camelot granted Mr. Putin pardon shortly after he began serving his sentence. Your Excellencies.
So your concern is the pardon which Mr. Putin was given, having been convicted.
Your Excellencies, the pardon and also the state's failure to compensate the victims of the illegal mining. Your Excellencies, we do acknowledge that Camelot prosecuted Mr. Putin and sentenced him. However, it is our submission that such criminal accountability is not sufficient because the respondent state has failed to compensate the victims of the illegal mining. Your Excellency.
Yes. Take a question from my colleague.
What is the legal standard of compensation in international law that they are using?
Your Excellencies, the legal standard for compensation is that a victim who has suffered harm must be compensated in the sense that he must be given reparations in order to deal with the harm that has occurred. Your Excellencies, for this, we rely on the ILC articles on state responsibility from Article 34, Your Excellencies. Your Excellencies, in the present matter, the respondent state, through its High Court, awarded $3.5 million monetary compensation to the victims of the illegal mining. Not only this, the state, also through Camelot, obtained a pledge to compensate the victims of the illegal mining. But sadly, none of these compensations have until this very day been paid to the victims of the illegal mining. Your Excellencies, we do acknowledge.
Take a question.
Vous comprenez, vous avez besoin des oreillettes. Ok. Maître, vous parlez d'une compensation financière. Mais est-ce que la compensation financière est la plus idoine, la plus pertinente dans ce cas de figure? N'existerait-il pas d'autres compensations financières que le droit international pourrait imposer à l'État? Et si oui, lesquelles?
Most grateful for your question, Your Excellencies. Your Excellencies, our concern is in relation to the financial compensation because, as seen from paragraph 14 of the fact, the livelihood of these victims have been greatly affected, therefore leaving them extremely vulnerable and destitute. Your Excellencies, we are also before this court seeking that the court orders the respondent state to not take further steps to avoid, or rather, seeking for the court to make an order as to a non-repetition of the state's action in respect of the illegal mining.
All right, your time is up. Thank you.
Very well, Your Excellency. Your Excellencies, I respectfully yield the floor to the third counsel to address this court on the second and third issue, respectfully submitted.
Proceed.
Mr. President, Your Excellencies, may it please the court, Ajubi Kete Bando, third agent for the applicant, Gozanga Human Rights Association. In the next 15 minutes, I would be addressing this court on substantive issues 2 and 3 concerning the treatment of the children and the 20 GORA senior members at the villa, the limitation of the FSHS policy. With Your Excellency's permission, I would begin. Your Excellencies, on substantive issue 2 concerning the treatment of the children and the 20 GORA senior members at the villa, the applicant advances 2 heads of arguments. First, that the treatment of the children at the villa undermined their best interests, and second, that the detention of the 20 GORA senior members was arbitrary. On the first head argument, Your Excellencies, because of the vulnerability of children, Article 4 of the African Charter on the Rights and Welfare of the Child obligates states to ensure that in all measures taken, the best interest of the child is prioritized. This duty, according to the African Committee of Experts on the Rights and Welfare of the Child in Center for Human Rights versus Senegal, decided on 15th April 2014 as paragraph 34, imposes a primary obligation on states to take measures that would contribute effectively to the physical, psychological, and emotional well-being of the child.
Agents in determining whether the state has lived up to the obligation to uphold the best interests of the child in decision-making or deployment of measures. Is it an objective exercise or subjective exercise?
Your Excellencies, it is a subjective exercise as it is based on the discretion of the state. However, the state must ensure that the best interest of the child remains of primary consideration. However, Your Excellencies, in the present matter, 50 street children were detained at the villa, evidently from paragraph 19 of the facts. Your Excellencies, the villa is a prison surrounded by high walls and was heavily guarded. Your Excellencies, according to the 2015 United Nations report by the Special Rapporteur Joan Mendes on torture, detaining children under such conditions exposes them to emotional distress, fear, trauma, and even disturbs their mental health and character orientation. It is on these grounds that we submit.
Maître Bandeau, vous venez de mentionner des principes présentés par le haut rapporteur aux Nations Unies, mais est-ce que ces principes sont contraignants pour notre cours? Est-ce que vous ne pourriez pas plutôt nous présenter une jurisprudence qui serait contraignante pour notre cours, qui mettrait en évidence le fait que les enfants doivent être préservés?
Your Excellencies, admittedly, the report by the UN Special Rapporteur is only of persuasive effect by this court. However, in accordance with Article 60 of the African Charter, which allows this court to draw inspiration from instruments adopted by specialized agencies of the United Nations, we humbly implore this court to equally draw inspiration from the UN Special Rapporteur reports.
But that is applicable where there is no jurisprudence from the African Court or the Commission. And you need to start the burden of letting this court know whether there is no relevant jurisprudence.
Your Excellencies, the African Court has only had the opportunity to determine matters concerning children in the case of APDF versus Mali, 2016, One African Court Law Report, page 316. And unfortunately, the discussion of conditions such as what the children has been put in was not discussed by the African courts, and that is why Agent is imploring the courts to draw inspiration by the instrument of the UN in the circumstances. Your Excellencies, it is therefore our submission that instead of the respondent states detaining these children at the villa, they should have accommodated them in a much more suitable institution of care, such as a foster home, as they are obligated to under Article 25(2)(a) of the African Charter on the Rights and Welfare of the Child. To make matters worse, Your Excellencies, the respondent states returned these children to the streets where they found them after they had forcibly vaccinated them, evidently from paragraph 22 of the facts, in contravention with their very obligation to reunite these children with their families under Article 25(2)(b) of the African Charter on the Rights and Welfare of the Child. It is on these grounds that we submit that Sentefia undermined the best interests of the child in its treatment of the children at the villa. On the second head argument, it is our submission that the detention of the 20 GORA senior members was arbitrary.
So, Agent, were this called to make a positive or favorable finding that the respondent state actually breached its duty to protect the best interests of the child in the circumstances that we have canvassed, what remedy would be appropriate in the circumstances?
Your Excellencies, the appropriate remedy will be for the children to be compensated for the psychological harm that they have suffered, and for the respondent states to reunite, trace the relatives of these children, and reunite them with their families.
Is there any guide regarding the quantum of compensation which this court can decree as a remedial measure?
Admittedly, Your Excellencies, there isn't a guide. However, we are imploring this court to assess the injury that has been committed against these children to determine what will be financially accessible to remedy the violation. Your Excellencies, on the second head argument.
As before your second argument, the applicant defends that our children can deny the vaccination. In COVID time, your argument is our children can deny being vaccinated by the state's authorities?
Agent cannot understand what.
No, take it again. Now, the vaccination, which was compulsorily done, could it have been avoided by the respondent state, having regard to the public health crisis, which was prevalent in the respondent state?
Your Excellencies, the applicant acknowledges that the respondent state was indeed experiencing the outbreak of the COVID-19 virus. However, compulsory vaccination does not mean forcible vaccination. However, what we find in the present matter is that the respondent state, evidently from paragraph 22 of the facts, vaccinated these children without any form of explanation or testing, and as to the positive and negative side effects of this vaccine, despite their protestations.
And this brings to the fore the question my colleague judge is asking, that when it comes to vaccination, especially in the face of public health emergency, must the patient or the person be vaccinated consent before the state can do that?
Yes, Your Excellencies. Your Excellencies, the only circumstance where the state can override the consent of these children is if these children indeed had the COVID-19 virus, which would affect the public health. But the respondent state did not even test these children to ascertain whether they have the COVID-19 virus. And therefore, they should have at least, at best, Your Excellencies, obtained their consent before measuring out the vaccination on them. It is on these grounds that we submit that Sentefia...
Sorry. thank you for your presentation. I have a question for you. In what grounds did you ascertain that the state did not test in terms of evidence for COVID? We want to find some kind of evidence for you to bring before this court.
Much obliged, Your Excellencies. If I may direct this court to paragraph 22 of the facts, it expressly states that the respondent states, despite the protestations, vaccinated these children without any form of testing or explanation as to the positive and negative side effects of the COVID-19 vaccine. It is on these grounds that we submit that Sintefia has violated their rights.
By agent, you have assisted the court if you had alluded to World Health Organization guidelines on COVID-19 vaccination, as whether prior testing is mandatory before vaccination.
Your Excellencies, admittedly, prior testing is not mandatory before prior testing. However, at the same time, prior consent by the patient or by the person receiving the vaccine is necessary, Your Excellencies, because the right to health of every person entails the person's right of autonomy over his own body, including his right of refusal, according to the Nairobi guidelines on the rights on the socio-economic rights in Africa, specifically as paragraph 64 and 65. And so based on this, we still argue that the respondent state should have at least, in accordance with international law best practices, obtained the consent of these children before vaccinating them in the circumstance. On the second head argument, it is our submission that the detention of the 20 GORA senior members was arbitrary. Your Excellencies, any arrest and detention is arbitrary if it is not justified by law or followed by due process. And this is according to your decision in Onyanchi and Njoka versus Tanzania, 2017 2 African Courts Law Reports, page 65, specifically as paragraph 132. The applicant therefore argues that the detention of the 20 GORA senior members was arbitrary because Sintefia failed to follow due process. Your Excellencies, under Article 71D of the African Charter, any person who has been arrested and detained has the right to have his cause heard within reasonable time and before an impartial tribunal. Your Excellencies, this right cannot be derogated from under any circumstance whatsoever.
Can you give any assistance to this court regarding what will amount to reasonable time in terms of bringing arrested person to trial?
Your Excellencies, admittedly, reasonable time is undefined. However, the African Commission in Majuru versus Zimbabwe defined reasonable time to be 6 months, subject to the peculiar circumstances of every case. However, Your Excellencies, what we find in this matter is that throughout their 7-month detention, the respondent states never arraigned these 20 GORA senior members before any court for trial and only released them after they had been coerced to take the COVID-19 vaccine. It is on these grounds that we submit that Sintefia violated the African Charter and other international human rights norms in its treatment of the children and the 20 GORA senior members at the villa.
Now, will you still go by that argument where their detention was not detention for having committed a crime, but being quarantined in terms of being at risk for some public health emergency?
Your Excellencies, it is our submission that that would not hold in a circumstance because there is no evidence that these 20 GORA senior members had the COVID-19 virus, and so there was no need to quarantine them in the first place. And so the state still had the obligation to arraign them before a court for trial since they had arrested them for flouting their directive. I shall now proceed to address the court on substantive issue 3 concerning the limitation of the FSHS policy to 150 less endowed schools. On this, it is our submission that the limitation is discriminatory in nature and has consequently violated the right to education. Your Excellencies, equality of persons and the principle of non-discrimination under Article 2 of the African Charter are fundamental. As such, any limitation based on social origin which hinders the equality of treatment in the access to education is discriminatory, pursuant to Article 1 of the UNESCO Convention Against Discrimination in Education. The applicant therefore submits that the limitation of the FSHS policy to only 150 less endowed schools to the exclusion of the schools in the major cities discriminates against the poor urban students who are similarly placed with those in the rural areas. Your Excellencies, we do acknowledge that the right to education is a socio-economic right which states have a duty to progressively realize. And we also acknowledge that the state had been affected by the COVID-19 virus. However, we still submit that the limitation was not necessary because there were viable alternatives that the respondent state could have resorted to ensure the full implementation of the FSHS policy. First, Your Excellencies, the state could have simply capitalized on its precious Hugono tree, which evidently from paragraph 2 of the facts.
Agent, because of time, let's test this argument a little bit before your time is up. Is it not enough sign of good faith by the state having practiced universal free SHS and later on finding that resources are not adequate and wanted to scale down the scope of implementation? Is that not enough?
No, Your Excellencies. Inasmuch as we acknowledge this novel approach by the respondent states, the state cannot abruptly retrogress in its policies that it implements in its state. Your Excellencies, for this, we rely on General Comment number 13 on the right to education by the UN Human Rights Committees, which provides that a state cannot retrogress in its measures and would only be able to do so where it has proven that it has resorted to all viable alternatives in the respondent state. And here, Your Excellencies, it is our argument that the respondent state did not resort to all the viable alternatives before retrogressing in this FSHS policy.
Give us one important viable alternative which the respondent state could have availed itself of.
Much obliged, Your Excellencies. Your Excellencies, the respondent state could have capitalized on its precious Hugono tree, which evidently from paragraph 2 of the facts is primarily used for the production of immune boosters and drugs for respiratory-related diseases. Your Excellencies, considering that the COVID-19 is a respiratory disease, according to the World Health Organization, it was the perfect opportunity for Sintefia to generate revenue and attract foreign investment by capitalizing on this Hugono tree.
Very well, your time is up, so you have to yield.
Much obliged, Your Excellencies. If I may be of no further assistance to this court, I respectfully yield the floor to my co-agents to address the court on substantive issue 4. Respectfully submitted.
Yes, so yield. Just to be sure, the name is Trevor. Yes, proceed.
President, Judge, honorable members of the bench, good morning. My name is Trevor Kamau, fourth counsel for the applicant. I shall be addressing this court in the remaining 15 minutes in regards to Merit D. If this court seeks no further clarification, I wish to proceed. Much obliged to Excellencies. Morality, culture, religion, and the opinion of the majority cannot indeed be used as a justification for limiting the rights of the minority in a society. Your Excellencies, this is our position, especially in instances where the majority are monstrous towards the minority. In regards to Merit D, Your Excellencies, it is our submission that the refusal to register Center for Sexual Minority Rights was indeed a violation of the provisions of the African Charter. We submit this in 3 limbs of argument. Firstly, that the refusal to register Center for Sexual Minority Rights was discriminatory. Secondly, that the refusal to register Center for Sexual Minority Rights did not meet the limitation test as was set by this court in the case of Issa Konate vs. Burkina Faso and Victoria Ingabire vs. the Republic of Rwanda. Lastly, Your Excellencies, we shall submit that the refusal by the respondent state to register Center for Sexual Minority Rights was indeed a violation of the right to freedom of association. In regards to our first limb of argument, we submit that the actions of the respondent state was discriminatory. We cite the provisions of Article 2 and Article 3 of the African Charter, which collectively provides for the right not to be discriminated against. Your Excellencies, this was indeed confirmed by you, Your Excellencies, in the case of African Commission versus Kenya. Allow me to cite a scholarly thesis persuasively to you. I cite a thesis by Dr. Nancy Baraza, who was the former Deputy Chief Justice in the Republic of Kenya. Her thesis is titled, The Impact of Heteronormativity on the Rights of Sexual Minorities. In her thesis, Your Excellencies, she notes that indeed the provisions of the African Charter do not provide for sexual orientation as a ground for discrimination. However, Your Excellencies, she notes that the usage of the words other grounds opens up the provisions of Article 2 of the African Charter to interrogation or rather for inclusion of other grounds for discrimination.
But the agent, you are very much aware that the African human rights system is a very unique one to the African setting. And if you look at the preamble and all that, the cultural and traditions of Africa, a very important background. So on what basis do you want to invite this court to recognize sexual orientation as a maintainable ground for discrimination?
Much obliged to Your Excellencies. I cite the decision of the African Commission in Zimbabwe NGO Human Rights Forum versus Zimbabwe at paragraph 169, where the Commission allow me to proceed, Your Excellencies. I cite the decision of Zimbabwe NGO Human Rights Forum versus Zimbabwe at paragraph 169, where the Commission did in fact recognize sexual orientation as a ground for discrimination. The Commission went ahead and stated that, in fact, sexual orientation provides for equal treatment of persons despite their sexual orientation. Your Excellencies, that is the authority that we rely on. Again, Your Excellencies, allow me to cite Resolution 275 by the African Commission that was released in 2014, where indeed sexual orientation was distinguished or was recognized as a ground for discrimination. Much obliged to Excellencies. In regards to our second limb of argument, we submit that the limitation pursued by the State Republic of St. Sphere did not meet the 4-pronged test that was set by this court in the case of Issa Konate vs. Burkina Faso and Victoria Ingabire vs. the Republic of Rwanda. We admit, Your Excellencies, that in fact rights are not absolute and they can be limited. But again, Your Excellencies, for these rights to be limited, it ought to be provided for by law, it ought to be necessary, it ought to be proportionate, and it ought to be justifiable. We submit, Your Excellencies, that the State Republic of St. Sphere did not meet any of these tests. Allow me to begin by the requirement that the objectives of Center for Sexual Minority Rights were indeed in conformity with the law. We cite the decision of the African Commission in Malawi African Association and others was the Republic of Mauritania, where the Commission was of the opinion that any law on association ought to include an objective description of its objectives in order to determine its criminal objectives.
By agent, it is clear from the fact that the respondent state has the Unnatural Offences Act. And clearly, what Center for Sexual Minorities sought to do was to promote activities which are contrary to that legislation. So can this court actually entertain the argument that you are making now?
Much obliged to Excellencies. I shall answer your question in two arguments. Firstly, allow me to cite a decision of this court in Ajavon versus Benin, a 2020 decision under paragraph 122, where you held, Your Excellencies, that any limitation on the rights, on any right, the meaning of the words ought to be provided by law means that any limitation ought to be consistent with international set standards. Your Excellencies, we submit that the State Republic of St. Sphere, in the continued enforcement of the Unnatural Offences Act, does in fact violate the right of sexual minorities in St. Sphere as provided for under the provisions of Article 10 of the African Charter. In alternative, Your Excellencies, we note that we implore to this court that indeed there is a difference between the activities of sexual minorities and in fact what they sought to promote, or rather what Center for Sexual Minority Rights. Your Excellencies, I shall be demonstrating this in my next limb of argument. But in order to answer your questions, Your Excellencies, we note that St. Sphere is steeped in ancient tradition and culture. If indeed the respondent states were committed to promoting the rights of sexual minorities, then they can go ahead and enforce the Unnatural Offences Act, as the activities of Aisha under the provisions of paragraph 26 were only to promote the rights of sexual minorities, to be specific, the right to health, the right from homophobia, the right to lesophobia. And in fact, Your Excellencies, if they seek to indulge with what LGBT persons do in private, they can continue and enforce the Natural Offences Act.
Agent, can you show from the facts one instance where LGBTI person was denied access to health or any other right, for which reason this court should entertain the present argument you are making?
Much obliged to Excellencies. From the fact sheet, we are not told of any specific instance where these persons were denied their right to health. But again, Your Excellencies, allow me to note Resolution 275, where one of the recommendations from the Commission was that respondent state should refrain from interfering with the rights of these persons, including verbal attacks on these people. But again, Your Excellencies, under the imports of paragraph 25, we see a minister by the name Kwame Bukusu verbally attacking LGBTQ persons, Your Excellencies. We see the actions, or rather the words of the parents in St. Sphere who go ahead and term her as an agent of the dark. Your Excellencies, this, we submit, is a first step towards the limitation of rights of sexual minorities. Much.
Vous plaidez avec conviction et passion pour la non-discrimination à l'égard des personnes homosexuelles, notamment. Est-ce que pour légitimer et renforcer votre argumentation, vous pourriez présenter à notre cours des jurisprudences venant d'Europe ou d'Amérique latine qui conforteraient votre argumentation sur la nécessité de ne pas discriminer les personnes homosexuelles?
My lady, if I may beg your indulgence, I didn't hear your question. I didn't have a translation.
Those in charge of the translating gadgets, I think the volume went down. So
I will try in English. I'm able to do it in English.
Right. So can you do it in English?
Yes. So you present with passion the need to not discriminate homosexual persons, but can you rely on important trend at the European level or at the Latin American level, case law from the European Court, of the Inter-American Court, in order to legitimate more your argumentation?
Much obliged, my lady. Allow me to cite a decision from the European Court, but unfortunately, Council only remembers facts but cannot remember the law. But again, the European Court of Human and People's Rights was of the opinion, in a certain case, I can't remember the actual citation, that the limitations sought by the Republic of Russia for limiting 3 LGBTQ persons from registering their organization was in fact discriminatory and a violation of their right to freedom of association. Council stands guided on the citation of the case, but Council knows the facts of the case and the holding of the European Court. Much obliged, my lady. In regards to reasonableness and necessity, we cite that the actions of the State Republic of St. Sphere were unreasonable and unnecessary. We note the imports of paragraph 27 of Article 27.2 of the African Charter, which provides that rights ought to be exercised with due regard to the rights of others, common interest, and morality. Your Excellencies, we submit that firstly, morality cannot be used as a ground for limitation of this right. Your Excellencies, it's impossible for the respondent state to cite morality as an actual ground for limitation of the rights of fundamental rights of LGBTQ persons in St. Sphere.
Agent, I want to ask a direct question. Is there a right to sexual orientation or sexual preference within the African system?
Much obliged, Your Excellency. Indeed, the African Charter does not recognize any special right for LGBT persons. But again, Your Excellencies, the wordings of Article 10 of the African Charter is that all persons have the right to freedom of association. Your Excellencies, it's all persons, regardless of their sexual orientation. And as such, Your Excellencies, we submit that sexual minorities, or rather LGBT persons, have equal rights to all other persons, not only in St. Sphere, but also in Africa. Again, Your Excellencies,
one of topics of admissibility is that the request must be according to the African Charter and African rules. Some African countries argue that LGBT and this kind of topics are against the nature of African traditional beliefs. What is your opinion about this? Thank you.
Much obliged, Your Excellency. We note from statistics that at least 33 countries in Africa have criminalized LGBTQ rights. But again, Your Excellencies, at least 99% of African countries have gone ahead and ratified and adopted the African Charter. We submit that in as much as these countries have criminalized LGBTQ rights, Your Excellencies, these countries still tend to respect LGBTQ rights in Africa, Your Excellencies. But again, Your Excellencies, kindly pardon me on your question, I've forgotten my train of thoughts.
The question is an invitation for you to express your opinion as to whether the right of LGBTIs or the right to choose your sexual orientation, which is not explicit in the African Charter, whether that should be recognized, having regard to African tradition and African culture.
Much obliged, Your Excellencies. In response to your question, allow me to cite the ICCPR General Comment number 21 under paragraph 12 and paragraph 13, where they cite that culture is the way of life. But again, Your Excellencies, the committee notes that culture can in fact be practiced by a group of persons or by a community, Your Excellencies. In as much as African culture, or rather, in as much as African states might cite culture as indeed a limitation of these rights, we note that firstly, culture is not static. Culture can change, Your Excellencies. And as such, if people intend to practice these rights as a small group, they ought to be accorded these rights. But again, Your Excellencies, guided by the fact sheet, Your Excellencies, Aisha has been existing in St. Sphere. Your Excellencies, she formally identified herself as Felix Caesar, Your Excellencies. Your Excellencies, under paragraph 25, the State Republic of St. Sphere knew quite well that Aisha exists. Your Excellencies, we note that her tweet was in 2021, but the respondent state first curtailed her rights in 2022. And as such, Your Excellencies, these people exist within our community. We recognize them, Your Excellencies. And that's why, Your Excellencies, we approach this court for the enforcement of these persons' rights, Your Excellencies. Much obliged, Your Excellencies. In regards to necessity, we cite that, first of all, common interests. And I rely on the case of Constitutional Rights Projects and others versus Nigeria, where the Commission noted that the African Charter does not contain any derogation clause. Your Excellencies, as I've earlier alluded, the respondent state knew of the existence of Aisha. Your Excellencies, under paragraph 24, her tweet was made on 16th July 2021. Under paragraph 25, Your Excellencies, Aisha has been advertising in the local televisions in St. Sphere. We submit, Your Excellencies, that citing common interest, collective security as a ground for limitation of this right cannot be justified. The people who are visiting Aisha's center were aged around 20 years, Your Excellencies. These are adults, Your Excellencies. These are people who have the right to freedom of choice, Your Excellencies. We submit, Your Excellencies, that the limitation pursued by the government of the Republic of St. Sphere was unnecessary. In regards to proportionality, Your Excellencies, we note the provisions of Article 10, which provides that rights ought to be exercised in accordance with the provisions of Article 29, which provides for the right to culture. In the case of constitutional projects and others versus Nigeria, it was noted that limitation of rights ought to be directly proportional to the intended purpose. Proportionality is concerned with the less restrictive measure that ought to have been accorded by the government. We note the case by the African court in APDF and IHDR versus Mali, where the respondent state was relying on insufficiency, or rather on its traditional values, as a ground to promote retrogressive cultural values. But again, Your Excellencies, you held that the respondent state ought to make sure that its national legislation are in accordance with the international obligations, Your Excellencies.
Agent, if this court were to make a favorable ruling on this particular claim, will you be inviting the court to hold all African states that do not recognize the rights of LGBT persons to be in violation of the African Charter and relevant human rights instrument?
Much obliged, Your Excellencies. We submit that each case ought to be determined based on its own peculiar circumstances. We will not be inviting this court. What we are arguing about is the right to freedom of association of these persons that has been guaranteed under Article 10 of the African Charter, and these persons ought not to be discriminated against. We are not asking you to rule that respondent states who have gone ahead and criminalized these activities should actually decriminalize them, but we argue that these persons, just like any other persons, have the right to associate and form organizations. Seeing that my time is far much spent, Your Excellencies, I seek 1 minute to submit on the last issue, or rather on the last sub-limb of our argument.
Go ahead.
Much obliged, Your Excellencies. In regards to our last argument, we submit that the actions of the respondent state was indeed a violation of the right to freedom of association. We cite the decision from the African Commission in the case of law offices of Suleiman Ghazi, where the Commission found that the actions of the respondent state of preventing Mr. Ghazi from interacting with other members of the society and discussing human rights matters and going ahead to punishing him was in fact a violation of the right to freedom of association. Having established, Your Excellencies, but the actions of the Republic of St. Sphere was discriminatory, was not provided for by law, was unproportionate, and was unnecessary, we submit that restricting this right was indeed a direct infringement of the right to freedom of association. We also urge you to be guided by the decision of the African Commission in the case of Civil Liberties Organization versus Nigeria under paragraph 14, where the Commission noted that the right to freedom of association includes an obligation not to interfere with the rights of persons, Your Excellencies.
Agent, I think your time is up.
Much obliged, Your Excellencies. Seeing that my time is far much up, Your Excellencies, the applicants wish to rest their case.
For health reason, we are not moving out, but we are getting up for 2 minutes and then we sit down. It's not good to be sitting down continuously for 2 hours. Yeah. So if you want to get up, but we will resume very soon.
Recalled, we hear agent for respondent.
Case record. Shall we have submission by agent for respondent?
Monsieur le Président, honorable juge, le temps qui nous est imparti sera reparti comme tel. Nakoulma Devi en 15 minutes sur les questions préliminaires, Daniel Marakourou en 15 minutes sur l'allégation A du fond, Martha Kemei en 18 minutes sur les allégations A, autant pour moi sur les allégations B et C du fond, et Rachid Tiemtouré en 15 minutes sur le D du fond.
So your name again, Ziburaku? Your name again?
Nakoulma Devi.
Marakaru? No. All right, that's a different one. Yes. So give me the second. Oh, right. Makulma, right. Yes, proceed.
Je suis chargé de vous entretenir sur les questions préliminaires. Mes trois confrères s'entretiendront avec vous sur le fond de la défense. Avec une vingtaine de traités de droits de l'homme ratifiés, 6200 ordonnances de recommandation en faveur des plaignants et victimes de violations des droits de l'homme, sur plus de 7200 plaintes enregistrées. Tel est le modeste bilan dont peut se targuer Saint-Sifia. En témoigne son prix Christof Heyns Gold Backstone. Monsieur le Président, éminent membre de la Cour, nous sommes au regret de vous annoncer que concernant votre compétence, vous souffrez d'une double incompétence en l'espèce matérielle et temporelle. Concernant la recevabilité de la requête, la partie défenderesse soulève des exceptions d'irrecevabilité. Premièrement, le non-épuisement des voies de recours internes. Deuxièmement, la non-introduction dans un délai raisonnable. D'abord.
So, agent, do you concede that we have jurisdiction in terms of all the various dimensions of jurisdiction?
Can you repeat?
Do you concede we have all aspects of jurisdiction? To entertain this matter before we come to the admissibility.
Est-ce que vous considérez que nous avons la compétence?
Pour ce qui est des 4 critères cumulatifs qui fondent la compétence de votre cours, à savoir le critère matériel, temporel, territorial et géographique, en l'espèce, vous êtes incompétent tant sur le plan matériel que temporel.
Encore faut-il le démontrer. Vous allez le faire?
Bien sûr.
D'accord.
D'abord, les exceptions d'incompétence. Primo, votre cours est rationné matière incompétente. À la lumière des articles 3, 4 et 7 du protocole de Ouagadougou, votre cours est compétente pour connaître de tous les différends, de toutes les affaires relatives à l'interprétation de la charte, à l'interprétation et à l'application de la charte, du protocole et de tout autre instrument pertinent relatif aux droits de l'homme. Mais que faut-il entendre par instrument pertinent relatif aux droits de l'homme? Selon votre jurisprudence Action pour les droits de l'homme contre la Côte d'Ivoire, les conventions sur la corruption, sur la conservation de la nature et la Convention des Nations Unies sur les changements climatiques ne sont aucunement des instruments pertinents relatifs aux droits de l'homme. Par conséquent, Par conséquent, des supposées allégations portant sur ces traités suscités ne rentrent aucunement dans le champ de votre compétence matérielle.
Excusez-moi, maître. Est-ce que vous pouvez nous citer les paragraphes précis de l'arrêt APDH contre Côte d'Ivoire qui mentionnent précisément que les conventions que vous venez de mentionner ne sont pas des traités de protection des droits de l'homme?
Ok, dans l'arrêt Action pour les droits de l'homme contre la Côte d'Ivoire, il n'est pas dit expressément que la convention, sur les conventions suscitées, ne sont pas des instruments pertinents relatifs aux droits de l'homme. Mais plutôt, il a été posé le principe de ce qu'il faut entendre par un instrument pertinent relatif aux droits de l'homme, qui, en son paragraphe de l'affaire, bien sûr, 57, fait ressortir que pour qu'on puisse qualifier un instrument pertinent relatif aux droits de l'homme, il faut se fonder sur l'objet, principalement sur son objet, qui soit cet instrument accorde des droits individuels ou collectifs, soit que cet instrument impose des obligations internationales aux États en matière de droits de l'homme. Et en faisant une étude analogique, nous tirons la conclusion que les conventions sur les changements climatiques, sur la corruption et sur les ressources naturelles, vous conviendrez avec nous bien sûr, ne prévoient pas expressément des droits aux individus et n'imposent pas non plus des obligations internationales aux États en matière de droits de l'homme.
Alors sur le premier point, on peut vous suivre. Sur le second, c'est quelque peu plus discutable. Le fait que des obligations imposées aux États en matière de droits de l'homme, si on pense environnement et droits de l'homme, il y a des liens très très forts, par exemple, ou corruption et protection des droits de l'homme. Donc il y aurait bien des obligations imposées aux États de lutter contre la corruption pour assurer une société plus démocratique et donc plus respectueuse des droits de l'homme. Vous voyez, il y a des liens que l'on peut faire.
Comme nous l'avons dit dans le paragraphe 57 de l'arrêt APDHP contre la Côte d'Ivoire, il ressort clairement qu'il faut se fonder sur l'objet qui reconnaît expressément les droits aux individus ou encore impose des obligations internationales aux États. Et même dans l'affaire Arma Gueye contre la Côte d'Ivoire, la Cour africaine des droits de l'homme et des peuples a reconnu que la Convention de Vienne sur les relations consulaires est un instrument pertinent relatif aux droits de l'homme, mais a reconnu que dans cette convention, on peut tirer des droits de l'homme, mais en vertu de l'article 30, lettre B de la Convention de Vienne sur les relations diplomatiques, qui, si je peux me le permettre sans le dire express, si je peux me le permettre, qui impose aux États l'assistance consulaire. Et vous conviendrez avec nous que dans l'assistance consulaire, il n'est aucunement dit que les États ont une obligation de procès équitable. Il a fallu que la Cour se rabatte sur la charte pour pouvoir tirer une conclusion que la Convention de Vienne sur les relations diplomatiques est un instrument pertinent relatif aux droits de l'homme. Donc en cela, on ne peut pas se fonder sur un instrument qui ne reconnaît pas expressément. On se fonde toujours sur un instrument ou encore on fait un flashback sur la charte qui reconnaît expressément des instruments.
Where there are activities which seek to destroy the environment, should this court ignore as not having relevance for human rights?
Pouvez-vous reprendre s'il vous plaît? Je n'ai pas pu saisir le deux.
Where you have activities such as you alluded to climate change, where you're talking about illegal mining and all that, which destroy the environment, should we ignore them as not being relevant to human rights?
La question est de savoir, dans des situations de changement climatique, de destruction de l'environnement, est-ce que cette Cour-là n'a pas la compétence pour connaître de cette affaire.
Si je comprends bien, en cas de changement climatique, est-ce qu'on peut poursuivre un État devant votre auguste cour? Telle est la question.
Yes.
En matière de changement climatique, on ne peut pas poursuivre un État devant votre auguste cour parce que même les États qui se disent développés, je cite ici les États-Unis, la Grande-Bretagne et la Chine ne sont même pas en reste pour ce qui est du changement climatique. Et si je ne me trompe, l'ouragan Katrina qui a fait des ravages aux États-Unis a causé des dégâts énormes. Et en cela, l'État est incapable. Et du moins, tous les États sont incapables en matière de changement climatique, quitte à se donner la main pour aller vers des conventions qui réglementeront cela. Comme nous l'avons relevé, votre cour est matériellement incompétente pour ce qui est des allégations d'exploitation minière illégale et des faits de corruption. Secondo, votre cour est temporellement incompétente. Cette compétence, bien que n'étant pas prévue expressis verbis par le protocole de Ouagadougou, tire son essence soit de la jurisprudence, soit de la doctrine. Et dans l'affaire Commission africaine des droits de l'homme et des peuples contre la grande jamaïria arabe, libyenne, populaire et socialiste, entendez par là la Libye, il ressort que les dates clés à prendre en compte dans la détermination de la compétence temporelle de votre cour sont celles de l'entrée en vigueur de la charte et du protocole. Et au juge Fatsa Ougerbouz de nous préciser, dans son opinion individuelle, que la date critique à prendre en compte est celle du dépôt par l'État de la déclaration prévue à l'article 34.6 du protocole de Ouagadougou. Dans le cas d'espèce, des allégations de corruption se sont produites en 2017, paragraphe 17 du rapport factuel, et en 2018, paragraphe 12 du rapport factuel, soit 2 ans avant l'intervention de la déclaration prévue à l'article 34.6 de Ouagadougou. Il plaira donc à votre cour de partir du constat que des faits de corruption sont antérieurs à la déclaration facultative faite par Sensifia le 5 juillet 2019. Et en se fondant sur cela, votre cour est incompétente pour se prononcer sur ces dites allégations. Tout compte fait, concernant votre compétence, de vous convaincre d'une chose claire et limpide. Vous êtes incompétent tant sur le plan matériel que temporel. Nous aurions pu nous en limiter là, mais la requête est tout aussi évidente, irrecevable. Maintenant, nous soulevons les exceptions d'irrecevabilité. À l'aune de l'article 56 de la Charte, par renvoi de l'article 6.2 du protocole, contrairement à ce que avançaient nos confrères, la Charte africaine à son article 56 ne prévoit pas les conditions de recevabilité de la Cour, mais plutôt celles de la Commission. Il a fallu attendre le protocole de Ouagadougou pour pouvoir qui fait un renvoi à cet article 56 de la Charte. Il ressort de cet article que les voies de recours internes n'ont pas été épuisées. Premièrement, épuisées et la requête n'a pas été introduite dans un délai raisonnable. Premièrement, les voies de recours internes n'ont pas été épuisées pour ce qui est des points A, B et C du rapport factuel, alors que les voies de recours internes sont disponibles, suffisantes et satisfaisantes à l'aune de l'article 56, alinéa 6 de la Charte, par renvoi de l'article 6.2 du protocole de Ouagadougou. D'abord, les faits de corruption. Les investigations sont toujours en cours, mais justifiées par le fait que la corruption est une infraction complexe qui demande beaucoup de temps dans l'investigation. En effet, dans l'arrêt du 21 juin 2013, Norbert Zongue auto contre le Burkina Faso, paragraphe 121, votre cour a estimé que ce qui constitue un retard injustifié doit être déterminé au cas par cas. Et toujours, votre cours d'ajouter dans l'affaire William et autres contre la Tanzanie qu'un retard est justiciable si l'affaire est visiblement complexe et difficile d'avancer dans les enquêtes. Le comité de l'Organisation des Nations Unies sur les drogues et la corruption, dans son rapport de 2004 sur la corruption, fait ressortir que les crimes les plus graves et les plus complexes, il ressort également la corruption. Monsieur le Président, honorable membre de la Cour, ces développements justifient ici à suffisance que la procédure d'enquête devant le BPS au paragraphe 17 du rapport factuel, la partie requérante devait attendre que l'enquête soit bouclée avant de porter l'affaire devant votre auguste cour. La requête est donc prématurée. Ensuite,
excusez-moi, maître. Dans l'analyse du délai raisonnable, vous prenez en compte la complexité de l'affaire de façon pertinente. Est-ce qu'il n'y a pas d'autres éléments qui peuvent aussi rentrer en ligne de compte? Et si oui, lesquels, selon la jurisprudence tant de la Cour africaine que des standards internationaux posés par d'autres tribunaux?
Ok, pour ce qui est de la raisonnabilité du délai, oui, il existe d'autres exceptions. En cela, on cite l'affaire Alex Thomas contre Tanzanie, dans laquelle votre auguste cour a fait ressortir que la raisonnabilité du délai peut s'apprécier au regard de la qualité du requérant, à savoir soit que le requérant est un profane, détenu en prison, ou encore n'a pas connaissance de l'existence de la Cour. Alors qu'en l'espèce, Madame la juge, l'ONG Gora, ici présente, au paragraphe 8 du rapport factuel, dans les dernières lignes, il ressort clairement que l'ONG Gora a une connaissance bien pétrie du système africain des droits de l'homme et a porté nombre d'affaires devant la commission.
En effet, j'ai bien lu votre travail, mais quid de l'attitude des juridictions internes qui, elles aussi, peuvent être à la base d'un délai irraisonnable? Est-ce que vos juridictions, les juridictions de votre État, ont traité dans un délai correct, sans opérer des formules dilatoires, le traitement de la corruption? Parce que dans l'analyse du délai raisonnable, il y a aussi l'analyse de la propre attitude des juridictions internes. Se sont-elles comportées, les juridictions de votre État, de façon rapide? Est-ce qu'elles ont traité correctement, rapidement l'affaire?
En l'espèce, il ressort que le délai raisonnable pour ce qui est devant la Cour d'appel est de 2 ans. Or, en l'espèce, les 2 ans ne sont pas encore atteints. En conséquence, le fait que les requérants aient porté l'affaire, quand bien même le délai n'a pas encore été atteint, vous conviendrez avec nous que cela est prématuré.
In African Union, we have the Executive Council Against Corruptions. Can you tell us if your states follow any recommendation of this Executive Council Against Corruptions? Thank you.
S'il vous plaît, pouvez-vous reprendre?
Okay, I am asking, according to the African system, we have an Executive Council Against Corruptions. My question is, do the states follow the recommendation of this council?
Merci pour la question. Effectivement, selon l'Union africaine, les États doivent assurer certaines garanties. En cela, premièrement, ceux qui se plaignent, les plaignants des faits de corruption, doivent être anonymes. En cela, la République de Saint-Sifia a mis en place une plateforme en ligne qui permet à ses citoyens de dénoncer anonymement les faits de corruption. Ensuite, à côté de cela, on ajoute le fait que Vu la gravité ou encore les conséquences de la corruption sur l'économie de Sensifia, cet État a mis en place le bureau du procureur spécial, à l'exemple du Ghana, pour lutter efficacement contre les faits de corruption. Donc en cela, monsieur le juge, vous conviendrez avec nous bien sûr que Sensifia a mis en place tout ce qui est de son pouvoir pour lutter efficacement contre les faits de corruption.
Your time is up, but because of the translation, I'm adding 1 more minute to enable my colleague to the right to answer your question.
Thank you, Judge. My question is, it is necessary to be expressively in the treaties that the object with regards to human rights, for instance, when there is a situation where for instance, in this case, for the mining, look for the fact that the mining activity was causing harmful to the environment and to the people. Can we not infer from this court with regards to material jurisdiction that we have jurisdiction to attend this matter as long as the issue that comes from those treaties and conventions affects the human rights? I want to hear about that.
Ok, merci pour la question. En cela, nous invoquons l'affaire Norbert Zongo et autres contre le Burkina Faso, dans laquelle il ressort que votre cour peut connaître, ou du moins votre cour a fait la distinction entre ce qu'il faut entendre par violation instantanée et violation continue. En se fondant sur l'article 14 du projet d'article de la CDI sur la responsabilité internationale de l'État pour faits illicites qui date de 2001. Il ressort de l'article 14, lettre B de ce projet, cité par la Cour, qu'il faut distinguer ce qu'il faut entendre par violation instantanée, dont le fait négateur des droits de l'homme s'est produit instantanément. À ne pas confondre avec la violation, quand bien même la violation instantanée peut avoir des effets qui vont se répercuter dans le futur. À ne pas confondre avec ce qu'il faut entendre par la violation continue, dont le fait négateur des droits de l'homme s'est poursuivi après, en l'espèce, pour ce qui est du cas du Burkina Faso, pour ce qui est de Norbert Zongo contre Burkina Faso, de la déclaration facultative prévue à l'article 34.6 du protocole. En cela, les prévisions du programme des Nations Unies sur l'environnement, qui prévoyait des dégâts inestimables d'ici 2005, ne rentrent pas dans le cadre de la compétence temporelle de votre auguste cour.
All right, your time is up. Your time is up, so yield to your colleague.
Merci, Monsieur le Président. Je cède le prétoire à Daniel Makour.
Yes, proceed.
Presiding Judge, Your Excellencies, recognizing all the languages represented in this dispute, allow me to say good morning, bonjour, hola, and assalamu alaikum. My name is Daniel Morakaru, and I will be addressing this honorable court on merit A with regards to holding Mr. Putin and Mr. Nsana accountable. At the very onset, members of the bench, we would like to disagree with the arguments made by the applicant.
Excuse me, let's hear your name well. Is it, say your name again?
Presiding Judge, my name is Daniel Morakaru.
You've missed it up, yeah, all right.
All right, proceed.
Thank you, Presiding Judge. At the very onset, we, as the respondents, would like to disagree with the applicant's submissions that we violated the Charter and other international human rights norms with regard to how we held Mr. Putin and Mr. Nsana accountable. We shall show to this particular court that we indeed met our obligations as enshrined in the Charter. We shall do this in two ways. First, with regards to Mr. Putin, and second, with regards to Mr. Nsana. Turning to the first limb on Mr. Putin, it is an undeniable truth that illegal mining has been taking place in Sensifia. However, we as the respondents submit that we have not been silent and have taken action towards curbing the illegal mining. Your Excellencies, Article 24 of the African Charter provides for the right to an environment conducive for development. Furthermore, the African Commission, in the 2001 decision of Sirac versus Nigeria, particularly in paragraph 52, mandates states to ensure that they punish those people who destroy the environment. Your Excellencies, as can be seen in paragraph 13 of the fact sheet, the Sensifia's Minerals Commission conducted a night raid. And during that night raid, they were able to arrest 50 Camelotian nationals who were conducting illegal mining on unlicensed concessionary lands. Thereafter, the Republic of Sensifia arrested Mr. Putin, who is the legal owner of Adrix Limited and Angold PLC. Your Excellencies, in the spirit of cooperation as enshrined in Article 3K of the African Union Constitutive Act, the Republic of Sensifia decided to extradite Mr. Putin to the Republic of Camelot. Your Excellencies, this decision to extradite was based on the following circumstances. First, the Republic of Camelot promised that Mr. Putin would get a heavier punishment of 15 years as compared to what we had in Sensifia, that is 3 years imprisonment.
By agent, you've already said that where the environment is being destroyed, the state is obligated to punish. Now, where you have extradited Mr. Putin to Camelot, he is convicted and in no time he's pardoned. Has the state of the respondent, has it actually lived up to its obligation to punish those who destroy the environment?
Much obliged, Your Excellencies. And in answering your question, we would like to submit that first, Mr. Putin was a Camelotian national, and therefore, according to public international law, both the Republic of Camelot and the Republic of Sensifia had the right to either prosecute him. And it is in that regard, Your Excellencies, that we decided to extradite Mr. Putin to the Republic of Camelot based on the following circumstances. That first, he would get a heavier sentence of 15 years imprisonment. And second, the fact that the people of Akan were going to get a compensation package of $7 million US.
Sorry to interfere. I think the mic system is said that if you are too close to it, it gives a bad feedback. So if you can create a bit of a distance. Great, thank you.
Much obliged, Your Excellencies. Proceeding to our arguments, the applicants have raised two main issues. That first, we did not prosecute Mr. Putin, and secondly, that we failed to compensate the people of Akan. However, Your Excellencies, we have demonstrated to this court that we held Mr. Putin accountable by extraditing him to the Republic of Camelot, where he was prosecuted and later served a sentence of 2 years and 4 months. Your Excellencies, to that extent, we consider that we performed our obligation with regards to punishing Mr. Putin. On to the second limb, with regards to the failure to compensate. Your Excellencies, the people of Akan, who are the victims in this particular case, were compensated in two ways. First, through the extradition agreement, the Republic of Camelot promised to pay them $7 million. And secondly, the Sensifian courts have awarded the people of Sensifia $3.5 million. However, Your Excellencies, we would like to submit that we have not yet realized the compensation with regards to the people of Akan. And this is why. Your Excellencies, there is a difference in time with regards to the time that this matter has been brought before this court and the time that we agreed to compensate the people of Akan. Your Excellencies, we were facing the economic situations, the harsh economic situations that were brought about by COVID-19. And Your Excellencies, we ask you to draw inspiration from the International Law Commission's draft articles on the responsibility of states against wrongful acts, particularly Article 25, which states that states can be precluded from wrongful acts on the ground of necessity, so long as it is to protect an essential interest against an imminent peril. Your Excellencies, we submit that at that particular moment, we could not be able to give the people of Akan the $3.5 million. However, Your Excellencies...
President, before you move on, you cited the ILC draft article on state responsibility.
Yes.
What is this status in international law and before this court?
Your Excellencies, the status of the ILC draft commission articles is customary, is part of customary law of international law, since according to the statute of the ILC, Statute of the International Law Commissions, the commission is mandated to draft articles, I beg your pardon, it is mandated to ensure that it drafts the state practices with regards to international law. Furthermore, Your Excellencies, Article 60 of the African Charter asks this court to draw inspiration from...
Before this case, is there any jurisprudence from the African Court or Commission in which the ILC draft articles on state responsibility has been relied upon?
Your Excellencies, we unfortunately do not have any decision whereby the court has relied on the ILC draft articles. However, we are persuasively asking this particular court to consider the draft articles while it retires to make its judgment. Your Excellencies.
Yeah, proceed.
Thank you, Your Excellencies. Proceeding to the matter on compensation, we were submitting that we have not been able to compensate financially the people of Akan. However, as can be seen in paragraph 14 of the fact sheet, we have gone ahead to provide for them temporary shelters and also acquire new lands where we are going to relocate them. Your Excellencies, we therefore submit that we have done all we can to ensure that we protect and we punish Mr. Putin for illegal mining. Your Excellencies, if there are no questions, I will proceed to my second limb on Mr. Nsana.
Proceed.
Moving on to the second limb on Mr. Nsana, the applicants have submitted that we failed to hold Mr. Nsana accountable for corruption. However, before we address that, we would like to highlight to this court the various measures that we have taken according to our obligation in the African Union Convention on Preventing and Combating Corruption, hereinafter referred to as the Convention on Corruption. Firstly, according to Article 5.1 of the Convention on Corruption, Sensifia has established corruption offenses under Section 175 of Sensifia's Criminal Code. Secondly, according to Article 5.5 of the African Convention on Combating Corruption, Sensifia has put in place an anonymous reporting system which allows witnesses to report corruption allegations without any fear. And thirdly, according to Article 5.6 of the Convention on Combating Corruption, we have gone ahead to establish anti-corruption institutions which are mandated to investigate corruption matters in Sensifia. Your Excellencies, the main issue with regards to holding Mr. Nsana accountable raises from the fact that we have not conducted investigations. However, Your Excellencies, in discharging the obligation to investigate, the African Commission in Zimbabwe NGO Forum versus Zimbabwe, particularly in paragraph 158, stated that this court should consider the effort in which the state has taken towards conducting those investigations. Your Excellencies, we submit that the Republic of Sensifia has exerted effort towards ensuring that it conducts investigations against Mr. Nsana.
Is it not worrying that the very special Office of Special Prosecutor, set up to deal with the corruption, simply abdicated its responsibility when the Commission on Human Rights came to the conclusion that there was no case for corruption?
Your Excellencies, we indeed recognize that the Office of the Special Prosecution decided not to conduct or open any further investigations after the Commission on Human Rights and Administrative Justice stated that Mr. Nsana was not corrupt. However, Your Excellencies, a reading of paragraph 17 of the fact sheet shows us that the Attorney General of the Republic of Sensifia approached the High Court and asked the court to ask the Office of the Special Prosecution to open extra investigations against Mr. Nsana. Your Excellencies, we submit that these investigations are still ongoing as the witnesses in this particular case did not leave any contacts or any evidence to buttress the allegations. We submit that the 2 years delay is justifiable because the Office of the Special Prosecution is taking its time towards identifying who are the witnesses and what is the evidence that they had.
But Agent, is it not the case that the Office of Special Prosecution is already prejudiced, having already come to the conclusion that agreeing with the Commission for Human Rights, there's no corruption? The High Court quashes it, and then it says that I'm going to investigate that which I've already concluded there's no corruption.
Your Excellencies, we beg to disagree that the Office of the Special Prosecution is biased. Your Excellencies, it is not biased as it is an independent organization that is established in the Republic of Sensifia according to the Office of the Special Prosecution Act. Your Excellencies, seeing that my time is far much spent, I would like to ask this court to graciously allocate me 1 more minute.
30 seconds.
Much obliged, Your Excellencies. It is in that regard that we submit that we did not violate the Charter or any other international human rights norms in our handling of the claims against Mr. Nsana, as we have exerted numerous efforts towards ensuring that we investigate him. Your Excellencies, thank you so much for your time, and I will now yield the floor to my co-counsel, Ms. Martha Jepkemei. Yes.
Yes, take a question.
Just a last observation. In your submissions, allegation A, you wrote Mr. Putin with U, P-U-T-I-N. And after that, you wrote Mr. Putin with P-O-U. Which one are we talking about?
Your Excellencies, thank you for that question. That was apologies for that.
Be careful with your response.
Your Excellencies, in responding to that, we apologize for that small clerical error.
It's okay.
Yeah, we were referring to Mr. Putin with the U. Thank you so much.
Not that one.
Not the other one with the O. Thank you so much, Your Excellencies. Have a lovely afternoon.
All right.
Judge President, Your Excellencies, whenever you're ready. Once again, Judge President, Your Excellencies, good afternoon. My name is Martha Jepkemei, appearing as the third counsel for the respondent. I will addressing two issues, Merit B and Merit C, that is on the treatment of the children and Gora senior staff member at the villa, and thereafter I shall proceed to canvass the free senior high school policy. Having carefully listened to the applicant's pleading on two issues, we draw one conclusion, and that is, these two issues have one thing in common. They both entail the applicant's dissatisfaction with the respondent's reaction to COVID-19 and economic recession in St. Cecilia. This notwithstanding, what we would like to point out to this court at the very onset is that neither the right argued under Merit B nor those argued under Merit C are inherently absolute. They are either subject to limitation or subject to progressive realization. With this in mind, Your Excellencies, I'll proceed to our submission on Merit B. The applicants made their pleadings in two limbs. That first, the measures we adopted violated the best interest of the child principle, as well as the right to liberty of the Gora senior staff members. Members of the bench, I'll proceed to address the violation of the right to liberty. It is our submission that the detention in question is administrative detention and not the detention that is based on criminal matters. The difference, Your Excellencies, is that administrative detention is made via the President Directive, which can be seen in paragraph 19 of the facts. Allow me to rely to general comment number 8 on the right to liberty and security of persons as enshrined in Article 9 of the ICCPR, where the Human Rights Committee rightly noted that when it comes to administrative detention, Article 9.1 and 9.4 are only applicable in that matter. And therefore, Your Excellencies, Article 9.2 of the ICCPR, as well as Article 9.3, is not applicable. And that is with regards to taking the members that are detained to judicial members of the bench for criminal trial. It is on that basis that we submit that the submission by the applicant...
But Agent, if we are to go by your submission that was administrative detention, how do you justify the very high walls and then the armed guards?
Indeed, Your Excellencies, in response to the submission of very high walls and armed guards, our position is that the detention first detention was meant to curb the spread of COVID-19, but curtailing unregulated movement. The presence of armed guards, as can be seen in paragraph 19 of the fact, was to prevent anyone from moving out of the place that they were, that is the villa. Your Excellencies, the difference in the detention is not meant on the where these people are being placed, but rather the manner of implementation. I'll proceed to submit that the deprivation of liberty was not arbitrary. This is because it was a justifiable limitation that adhered to the limitation test set out by this court at paragraph 135 of Umuhoza versus Rwanda. That is, a limitation that is prescribed by the law that was necessary and proportionate to the legitimate aim pursued.
What were the facts of that case? What happened in that case, the authority that we just started?
Members of the bench, while the facts of Umuhoza versus Rwanda was with regard to the freedom of expression and the matters of genocide in Rwanda, the limitation set out by this court is applicable because it has been applied in all instances, and we may say that it adheres to in all cases of limitation of rights. With regards to legality, Your Excellencies, it is not in contention that the detention of the children and Gora senior staff members was prescribed by our laws, and that is the Imposition of Restriction Act that gave the President the authority to adopt directives that restrict on various light on purposes of public health. What is contention before this court is the proportionality of the detention.
Can a state vaccinate without the consent of parents or children?
Kindly pardon me, Your Excellency.
Even in pandemic situation, can a state vaccinate children without the consent of parents?
Much obliged to answer your question. With regards to vaccination of the children, indeed, the state can adopt compulsory vaccination. Relying on the WHO policy brief that was released in May 2020, the WHO indeed appreciated that states can adopt compulsory vaccination. And in accordance to the submission made by the applicant, they submitted this vaccination as forcible. Therefore, members of the bench, I'll proceed to differentiate the two. The vaccination in question was compulsory and not forcible. The difference is compulsory vaccination is allowed in law, while forcible vaccination is not. In the European Court of Human Rights, in the 2021 decision of Vavrika versus Czech Republic, the court proceeded to describe compulsory vaccination as a vaccination system that is made mandatory for everyone in the state for purposes of public health concerns. And in order to ensure compliance with this policy, the states are allowed to adopt restrictions such as restriction to the access of public services, or what happened in the case, restriction on movement. Your Excellencies, however, for forcible vaccination, it tends to be more diabolical. This can be seen from the Human Rights Watch report on what happened in China. In China, Your Excellencies, the police officer will barge in the people's house and take them to the vaccination center forcefully. We don't see any of that happening in the state of Sensifa. What we see is the respondent following the dictates of the European Court of Human Rights, restrict their rights until they accept. With regards to children, Your Excellencies, it is our submission that according to the UNICEF minimum guideline on consent, children lack capacity to consent. And therefore, members of the bench, this responsibility is bestowed.
Is that position absolute? Especially if you have the regards to municipal decision from the United Kingdom, like the well-known case of the 16-year-old child who was given contraceptive advice without the involvement of the parents and what the court said. Is it absolute that children, at all circumstances, can never give consent? The Gaelic, I'm talking about the Gaelic against the Norfolk and the West Beach Health Authority case.
I do not your concern, Your Excellency. As it stands for now, indeed, children lack capacity to consent. And what they're allowed to do, Your Excellencies, is to express their opinion. Allow me to finish up on the consent and then address expression. With regards to consent, Your Excellencies, the responsibility to give consent on medical matters is bestowed on the parents pursuant to Article 18 of the United Nations Convention on the Rights of the Child. However, Your Excellencies, as can be seen in paragraph 19 of the facts, the children in question are unaccompanied. And with regards to unaccompanied children, General Comment number 6 on the treatment of unaccompanied children at paragraph 2 defines unaccompanied children to be children who are not, they don't have parents or others to take care of them. And therefore this responsibility transfers to the state. It was on that basis that our state, the state of Sensifa, vaccinated the children. With regards to expression, members of the bench.
No, but before that, there's a consent that having vaccinated them, you took them to the street and just left them there. Especially so when there was a public health crisis.
Members of the bench, I'll answer your question in two ways. That first, the public crisis had ceased at the moment. This is because, as can be seen in paragraph 22 of the facts, we uplifted all the COVID-related bans and imposed compulsory vaccination. This was meant to ensure the return of the life of the Sensifians to normalcy. With regards to the issue of returning children back to the street, it is our concession that indeed that's a bad fact on the side of the respondent state. However, a keen look at what the applicant brought us before the court today is with regards to the treatment of the children in the villa. And that can be seen from paragraph 19. We accommodated them, catered for them, and took care of them. Members of the bench, it is right to conclude that in these 6 months, the children were able to get better care than what they have achieved in the life at the streets. Proceeding to our arguments, Your Excellencies, I'll proceed to address the proportionality of the detention. This court, in the case of Mtikila versus Tanzania, at paragraph 106, stated that a limitation is proportionate if it strikes a fair balance between the legitimate aim pursued and the harm to the right in question. And a fair balance is considered to be struck when the benefit of protecting the interest outweighs the harm to the right in question. Members of the bench, let us weigh and balance these two and see which carries the day. In terms of the harm suffered, indeed, the Gora senior staff members were not able to move at their will because they were constrained within the villa for 6 months. However, in terms of the benefit, the state was able to deter others from violating the president directive, therefore being able to keep COVID-19 at the minimum. Secondly, members of the bench, it is our submission by the time that we were releasing them, we were able to vaccinate them, and therefore their immune system were boosted and a creation of 93% defense against the virus. It is our submission that the measures were proportionate and therefore we did not violate the right to liberty. Allow me to address shortly the best interest of the child principle in accordance to the pleadings made by the applicant. The applicant submitted that by putting the children at the villa, we violated their rights. It is our submission, Your Excellencies, as initially stated, this was in their best interest. The applicant gave this quote as an alternative that perhaps he could have taken these children to a more suitable institution. However, it is our submission that that could be riskier to other children. Remember, members of the bench, that this time is when COVID-19 was at its peak. And when we took the children, we could not in certainty say whether they were affected or not. By taking them to other charitable children institution, members of the bench, will be a riskier method to other children living there, and therefore we could not do that.
So you are saying that it justified the trauma which the children were subjected to, having regard to the horrifying state of the facility in which they were placed?
Not at all. We can never justify trauma on children. Members of the bench, these children did not suffer any trauma. Allow me to rely on Article 37C. We agree that we deprived these children of their liberty and we proceeded to put them together with the adults. However, Rule 29 of the United Nations Rules on Protection of Children Deprived of Liberty states that under controlled conditions, children can be placed together with carefully selected adults, as it has proven to be a special program that enhances holistic development of children. May I remind this court that the Gora senior staff members were not hardened criminals. They were human rights activists, and being together with the children creates a safe environment for the children. Your Excellencies, it is our submission, therefore, that the treatment of the children and Gora senior staff members was in the best interest of the children and did not violate the right to liberty for the Gora senior staff members. Therefore, members of the bench, I'll proceed to converse on merit claim C. Regarding the free senior high school policy, the bone of contention is that we limited the scope of coverage of the free senior high school policy from covering 6,000 plus schools to only 150 schools. We agree, Your Excellencies, that even at face value, that's a retrogressive measure. However, principle number 20 of the African Commission Principles on the Implementation of Economic, Social, and Cultural Rights provided in the African Charter allows states to take retrogressive measures and by following particular guidelines. This guideline, Your Excellencies, provides that 1, the state must have carefully considered all the available alternatives. Secondly, the decision must be made in the context of the full use of maximum available resources. Members of the bench, we did all of this. Allow me to guide you to paragraph 21 of the facts. By the advice of the EMT, first, we increase export and import duties. We proceeded to increase the corporate taxes, further implemented the e-levy policy. However, it was so unfortunate that the only generatable revenue was 4%. The pooled revenue could not mitigate the economic situation of Sensivia. And it was at that time that the president decided to cut the finance of other government-sponsored policy, including the free senior high school policy. Secondly, Your Excellencies, regarding the maximum available resource, allow me to guide you to paragraph 1 of the fact.
But before that, we are also told that there are plants which are immune boosters, and you could have resorted to that so that you get resources to continue with the free SHS policy.
Members of the bench, I indeed had the alternative offered by the state of the applicants, and that is using the Huguenot trees. And as can be seen in paragraph 2 of the fact, the state of Sensivia is a state that values culture, and an instance of that culture is the highly valued Huguenot trees. By suggesting that we could have used Huguenot trees, Your Excellencies, is equally saying that we should have forced deforestation of places where we have these Huguenot trees, and therefore even proceed to violate the right of culture for the people of Sensivia. This is because, Your Excellencies, COVID-19 is a world pandemic. It's not just affecting a state or a particular place in Sensivia. It is affecting the whole country. How many Huguenot trees will we need in order to come up with enough vaccines? Secondly, Your Excellencies, we did not have the luxury of time and finance to extract these products from the Huguenot trees. It is therefore our submission that the alternative offered by the applicant is not applicable in this particular instance. Proceeding to the second limb of the argument on the use of maximum available resources, paragraph 1 of the facts provides that Sensivia is a lower middle-income country, and we majorly rely on foreign investments. According to paragraph 18 of the facts, foreign investment profits have reduced by 56%. And at this point, Your Excellencies, paragraph 21 of the facts shows that the investors are clearly running away from our state. We basically had little to no money to support the FSHS policy. It is therefore our submission that the retrogressive measure was justifiable. Regarding the act of discrimination, Your Excellencies, Committee on Economic, Social and Cultural Rights, in General Comment number 3 on nature of the state obligation, at paragraph 12, states that even in time of resource constraint, the state must make sure to provide for the vulnerable members of our society. Paragraph 1 of the fact shows the social stratification in Sensivia. We have the westernized and wealthy persons in the 16 regions of Sensivia, and we have the marginal income earners at 160 district assemblies, the 150 schools. Members of the bench, may you kindly graciously add me 30 seconds to conclude.
Proceed, 30 seconds.
Thank you for your grace. Regarding the issue of social stratification in Sensivia, we have the wealthy, westernized members in the 16 regions of the state. And we have the marginalized income earners, marginal income earners in the 160 district assembly. And as can be seen in paragraph 21 of the fact, the president rightfully stated that the 150 less endowed schools were picked from various rural areas in Sensivia. Therefore, Your Excellencies, the criterion that we use was more of vulnerability of the members of our society with regard.
Right, time up. Thank you.
Thank you, members of the bench.
Please get the microphone.
proceed.
Honorable juge, je suis Thiemtoré Abdul Rachid. Je suis chargé de vous entretenir sur la question du refus d'enregistrement du Centre pour les minorités sexuelles. Mais avant cela, permettez que l'on apporte certains correctifs aux allégations de nos confrères, car comme le dit l'adage, tant que les lions n'auront pas leurs propres historiens, les histoires de chasse ne peuvent que chanter la gloire du chasseur. Commençons par la question des enfants, parce qu'elle doit être certainement fraîche dans les esprits. La partie requérante estime que les enfants ont été gardés dans une prison. De mauvaise foi, parce qu'il est clair que suivant le paragraphe 19 du rapport factuel, que ces enfants ont été hébergés dans une villa, pris en charge et nourris. Élément factuel, déformation des faits. Deuxième élément juridique, honorable juge, à la question de savoir quelle est la pertinence de citer le Comité des droits de l'homme devant votre auguste cour, la partie requérante a fait allusion à l'article 55 de la Charte, pourtant il s'agit plutôt de l'article 61 et 60 de la Charte, qui d'ailleurs estime que la Cour s'inspire.
Do you mean the applicant or the respondent? You said the respondent said, but you are respondent.
Je voulais dire, honorable juge, la partie requérante. Et donc, sur la question, ils estiment que le comité, sur la question de la pertinence de mentionner le comité, il faut dire que la Charte dit que la Cour s'inspire et prend en considération. La Cour n'est aucunement liée à ce que le comité a dit. Honorable juge, revenons donc à la question de la prétendue violation pour refus d'enregistrement du Centre pour les minorités sexuelles. Distingué juge, Saint-Sifia n'est responsable d'aucune violation des droits de l'homme pour avoir refusé d'enregistrer le Centre pour les minorités sexuelles. Et pour le démontrer, nous allons nous fonder 1. Sur la Charte africaine, 2. Sur la jurisprudence de la Commission africaine et 3. Sur la conception que les États africains ont de la question. Saint-Sifia n'est pas un État oppresseur des personnes LGBT. Un État homophobe, comme on a voulu vous le faire croire, honorable juge. Bien au contraire, il n'en est rien. Mieux, Saint-Sifia manifeste une certaine tolérance à l'égard de ces minorités sexuelles. Pour preuve, les personnes LGBT exercent leur liberté de manifestation, d'expression, de rassemblement et de réunion. Aïcha a pu organiser au cours de ces dernières décennies des conférences publiques et a pu faire des déclarations sur ses comptes Facebook, Twitter et Instagram. Le Centre pour les minorités sexuelles a obtenu un bureau permanent à Seda, au cœur du pays, la capitale, et sa directrice elle-même, Aïcha, a pu sponsoriser des publicités télévisées sur les principales chaînes de télévision de Saint-Sifia. Honorable juge, tout ceci est perceptible au paragraphe 24 et 25 du rapport factuel et est la preuve incontestable que Saint-Sifia n'a aucun problème avec le respect des droits des minorités sexuelles comme le prétend la partie requérante. Le refus d'enregistrer l'association LGBT n'est pas une violation des droits de l'homme, mais plutôt une protection de cette organisation et des personnes LGBT étrangères. Honorable juge, nous considérons que notre société n'est pas encore ouverte sur la question de l'identité de genre et de l'orientation sexuelle. En témoigne, entre autres, la réaction des chefs religieux et des parents face aux manifestations et propos de Aïcha, de même que la réaction du ministre des Chefferies et des Affaires religieuses, Kwame Burkuzu.
But agents, we have been referred to a letter of examples from the African continent in which...
Okay, good. No translation, but
we have been referred to a plethora of examples on the African continent in which states have recognized right of sexual minorities.
Yeah.
And the facts even give examples per the advert that the transgender ran. So it's not alien to the African human rights systems.
It's okay, it's okay. Honorable juge, Merci pour la question. Effectivement, il y a des exemples de pays qui ont reconnu les droits des minorités sexuelles. Il y en a même à l'image de l'Afrique du Sud, qui a reconnu le mariage pour tous. Mais ce n'est qu'un exemple isolé. Et d'ailleurs, la majorité des pays africains, comme nous allons le démontrer dans la suite de nos observations orales, sont contre ces pratiques.
Je vous remercie pour ce commentaire, mais est-ce que notre cours prend en compte ce qui pourrait s'appeler un consensus africain quand elle statue? Parce que est-ce qu'il est important pour nous de savoir s'il y a une majorité ou une minorité d'États qui reconnaissent les droits aux personnes LGBT? Est-ce que vous pouvez mettre en avant, parce que c'est votre argument, l'existence d'un consensus africain, d'une majorité d'États. Mais est-ce que dans notre jurisprudence, nous prenons en compte cette idée du consensus africain pour statuer? Parce que si on le prend en compte, alors on valide le statu quo. Et si on valide le statu quo, on ne fait pas avancer les choses. Et je vous laisse répondre.
Honorable juge, votre cour est créé par des États africains qui ont signé justement l'instrument qui vous crée, et nous pensons que la Cour devrait aller dans le sens, n'est-ce pas, de la volonté générale de ces États dans ces différentes observations.
La volonté générale des États est discriminante. Alors,
honorable juge, si vous estimez justement que cet argument n'est pas pertinent ou n'est pas suffisant, en plus de cet argument, nous allons apporter d'autres arguments juridiques et jurisprudentiels pour vous convaincre. Donc, le refus d'enregistrer du Centre pour les minorités sexuelles s'explique aussi, en plus de la volonté de les protéger, par la volonté justement de préserver les valeurs traditionnelles qui, énoncées à l'article 17 alinéa 3 de la Charte, qui fait de la promotion et de la protection de ces valeurs reconnues par la communauté un devoir de l'État. C'est ainsi que la Constitution de Saint-Sifia, en son article 75.1, affirme son attachement à ces valeurs et que la loi sur les délits contre nature en fait autant. Honorable Cour, certes, ni la Charte, ni la Commission, ni la Cour ne définissent ce qu'il faut entendre justement par valeurs traditionnelles, mais au regard de l'hétérogénéité des sociétés et des cultures africaines, la Cour devrait laisser une marge nationale d'appréciation à chaque État dans la détermination de ces valeurs traditionnelles. Dans l'affaire Cambolé contre Tanzanie 2020, page 460, paragraphes 79 à 81, la Cour africaine, s'inspirant de la Cour européenne des droits de l'homme et des peuples et de l'ancienne Commission des droits de l'homme et des peuples, a jugé que lorsqu'il n'y a pas de convergence sur une question, elle devrait laisser la latitude aux États de décider de son contenu en fonction de leur réalité pratique. Honorable juge, votre auguste Cour, dans sa fonction de complémentarité, confirmait ainsi en 2020, 16 années après...
Agent, is that not too dangerous if we are to allow margin of appreciation to states regarding what amounts to traditional values? A lot of states will be taking advantage of that to violate so many other human rights obligations.
I'm sorry, I didn't get this question. If you can please...
I would like to know...
No, sorry, I mean in French, because I didn't get it.
Yes, so if the states are
French,
given
please,
the opportunity to determine what amounts to traditional...
Please, Honorable Judge, no translation, and I need the question in French.
Yes, in
because
French.
I'm not getting it.
You can put it. Yes. Yeah, so if the state is allowed to determine what amounts to traditional values, is that not too much of a window to enable the state to violate a lot of human rights human rights obligations in the name of traditional values?
Honorable juge...
Okay.
I got it, yeah, thank you. You got it. Honorable juge, le fait justement de s'accorder avec les États sur la question des valeurs traditionnelles n'ouvre aucunement une fenêtre à la violation des droits de l'homme. Car comme nous venons de le dire, Sentifia n'a aucunement violé, dans le cas d'espèce, les droits des minorités sexuelles. Il n'a fait que justement les protéger et d'autre part assurer la protection et la promotion de ces valeurs traditionnelles. Nous ne voyons pas en quoi un droit de l'homme a été en l'espèce violé. La liberté d'association, de réunion, la liberté d'expression ont tous été assurés et n'ont pas été violés.
Proceed.
Donc, honorable juge, effectivement, comme nous le mentionnons, dans l'affaire Kambolé contre Tanzanie, vous vous êtes référé à la Commission européenne des droits de l'homme et des peuples ainsi qu'à l'ancienne Commission des droits de l'homme et des peuples et vous avez considéré justement que la question de la marge nationale d'appréciation était pertinente. Au nom donc et en raison de cette marge nationale d'appréciation qui devrait être laissée à chaque État sur des questions comme celle en cause ici en l'espèce, honorable juge, la Cour devrait s'abstenir de faire le procureur des valeurs traditionnelles africaines et laisser chaque État décider si telle pratique est pour lui une valeur traditionnelle ou pas, ou encore si telle pratique contrevient à ce qu'il considère comme une valeur traditionnelle. C'est en raison de cela que Sentifia, pour protéger ses valeurs traditionnelles, a refusé l'enregistrement de l'ONG.
Cher maître, entre la protection des valeurs traditionnelles et le principe de non-discrimination, vers où penche la balance pour vous?
Honorable juge, je n'ai pas très bien compris la question.
Pas compris. Vous avez démontré, vous voulez démontrer, vous n'avez enfreint aucun droit des personnes LGBT en leur interdisant de défendre leurs droits. Donc déjà, on peut discuter parce qu'on pourrait dire que la liberté d'association est malmenée, mais surtout, en ne leur permettant pas de défendre leurs droits avec l'inscription de l'association, vous les discriminez par rapport au reste de la population. Mais vous les discriminez au nom des valeurs traditionnelles. Et donc, je vous demande, pour que je sois bien sûre, si vous voulez que notre cours, en réalité, c'est ce que vous nous demandez. Vous nous demandez de valoriser les valeurs traditionnelles au mépris du principe cardinal du droit international des droits de l'homme, qui est la non-discrimination. Alors, est-ce que vous continuez dans cette défense?
Honorable Cour, effectivement, il s'agit là d'un sacro-saint principe, le principe de la non-discrimination. Mais nous continuerons dans ce sens dès lors que la Commission elle-même, africaine des droits de l'homme et des peuples, a continué dans ce sens. Et c'est ce que nous allons démontrer tout à l'heure. Au demeurant, honorable juge, la Commission africaine elle-même, lors de sa 73e session ordinaire du 20 octobre au 9 novembre 2022, avait rejeté des demandes de statut d'observateur de 3 organisations au motif, honorable juge, que l'orientation sexuelle n'est pas un droit expressément reconnu par la Charte et qu'elle est contraire aux valeurs africaines. C'est ce même motif qui fonde justement le rejet de la demande d'enregistrement du Centre pour les minorités sexuelles par Sentifia. Honorable juge, la preuve est faite et elle est incontestable. Sentifia est un État qui respecte les droits de l'homme, mais seulement soucieux de l'effet immédiat et des conséquences futures que ces éventuelles autorisations peuvent avoir sur sa société.
Agent, if you look at the constitution of Sentifia, the provision on human rights, they have cited a provision which suggests that the human rights which the citizens are entitled to enjoy, I'm referring to Article 33, Clause 5, are not limited to the human rights that have been spelled out in the Bill of Rights, but any human right and freedom considered to be inherent in democracy are also to be enjoyed. An applicant cited examples from the European human rights system and their jurisprudence to ground the argument that the right to sexual orientation is also recognized in some democracies. What is your take on that?
Sur la question de savoir que la Constitution est ouverte justement au respect des principes des droits de l'homme évoqués par les autres instruments internationaux. C'est cela, honorable juge. Donc sur cette question, effectivement, la Constitution ne dénie pas les droits qui sont mentionnés par les autres instruments internationaux, mais comme nous l'avons dit, jusque-là, nous ne voyons pas, ou encore que la preuve n'a pas été faite, qu'en l'espèce, nous avons violé un droit de l'homme. Honorable juge, comme nous le disions, la preuve est faite, et si la Cour a encore besoin de preuves, voici-en une statistique. Selon l'UNESCO, en 2014, 33 pays sur 54 en Afrique avaient dans leur législation criminalisé les pratiques homosexuelles. Honorable juge, la majorité des États qui ont adopté et ratifié la Charte africaine et qui ont consenti à votre création, avec l'adoption du protocole de Ouagadougou qui vous crée, vous indiquent ainsi leur conception de la question qui fait l'objet de discussion dans ce prétoire. Qu'il plaise donc à votre auguste cénacle de reconnaître que le refus d'enregistrement du CDMS n'est pas contraire aux droits de l'homme. Si les honorables juges peuvent nous accorder 30 secondes pour terminer.
Right, 30 seconds.
Thank you so much. Honorable juge, dans l'esprit qui anime cette délégation, malgré sa diversité linguistique, nous amène à solliciter à ce que les honorables juges que vous êtes retirent leur casque de traduction afin que l'on finisse nos observations orales avec un dernier mot en anglais et traduit en français. Please. Please, honorable. Your Excellencies, we ask you, to scrutinize the respondent actions, not with skepticism, but with the recognition of the earnest intent to preserve and champion the well-being of the people of Sensifia. As you, with these decisions, remember that justice does not reside solely in statutes, but also in fulfillment of responsibilities. Responsibilities to those whose futures we hold in our hands. Translated in French, plaise à votre auguste cénacle d'examiner les actions de Sensifia non pas avec scepticisme, mais avec une reconnaissance de leur intention sincère de préserver et de défendre le bien-être de la population. Courant son délibéré qu'il n'échappe pas à la cour de séance que la justice ne réside pas uniquement dans la loi, mais aussi dans l'accomplissement des responsabilités envers ceux dont nous tenons l'avenir dans nos mains. Thank you so much.
Thank you. There's a last question.
All right.
Okay, just the last question. Okay, let me come back to one of the questions raised by our president about... en français, ok.
Yeah, better.
Ok. Donc, laissez-moi revenir sur une question qui a été posée par notre président concernant la tradition et la culture.
Concernant
la tradition, que nous devions prendre en compte les traditions de chaque État. Donc, juste pour dire que dans l'affaire contre le Mali, la Cour africaine avait jugé que l'État malien avait violé les droits de l'homme en ne permettant pas d'avoir une égalité entre l'homme et la femme ou entre la fille et le garçon quand il s'agit de droit à l'héritage. Également que la jeune fille devait se marier à un âge raisonnable de 18 ans. Si on veut tenir compte de la tradition, puisque l'État malien dit dans sa tradition, avec les islamistes, quand ils ont voulu changer la loi, il y a eu beaucoup de manifestations, de protestations, ils n'ont pas pu la changer. Et la fille, on pouvait la marier à 14 ans, à 13 ans. La Cour a estimé que ce n'était pas possible. D'ailleurs, il y a le protocole de Maputo sur les droits des femmes qu'il fallait respecter et tout ça. Est-ce que vous continuez de penser qu'il faut tenir compte de chaque tradition? Est-ce qu'on ne va pas aboutir à une discrimination entre les États? Parce que pour tel État, on va permettre certaines situations, pour tel autre État, on va permettre d'autres situations. est-ce qu'on n'aboutirait pas à une discrimination, à une rupture de l'égalité entre tous les citoyens?
Honorable juge, nous continuons à penser, nous insistons et nous persistons sur la question de la marge nationale d'appréciation que votre Cour elle-même a évoquée il y a 3 années de cela, en s'inspirant de sa consoeur européenne. Et donc, si la Cour elle-même est toujours sur la question, pourquoi nous, Parti défenderesse, allons-nous la quitter?
Je précise que lorsque la Cour a pris la décision d'imposer que l'homme et la femme soient égalitaires en matière de succession et que la femme ne se marie pas avant 18 ans, le Mali a accepté la décision et en pleine conférence des chefs d'État a estimé que comme la Cour a pris cette décision, elle pourra l'imposer aux islamistes dans son pays. Est-ce que vous continuez à penser qu'il faut laisser une marge de manœuvre aux États?
Absolument, honorable juge. Nous continuons à penser, nous insistons et nous persistons. Nous sommes là pour défendre un État et face à la Cour, nous ne pouvons pas flancher. Donc, nous disons et nous maintenons cette question. Merci beaucoup.
Right. Thank you, Agent. We shall now take rebuttal from the applicants, and then we will recess for deliberations and come back.
Your Excellencies, the applicant makes 5 points of rebuttal. First, the respondents have argued that the court does not have material jurisdiction over the UN Convention of Climate Change. However, you have held, in the case of APDF versus Mali, that the court would have material jurisdiction where the obligations under that treaty give rise to the protection of human rights. It is our argument that the UN Convention of Climate Change give rise to obligations which further protect the rights to satisfactory environment under Article 24 of the African Charter. And consequently, this court has material jurisdiction.
Sorry, is that Bando or Anan?
Bando.
Right.
And consequently, this court has material jurisdiction. Second, Your Excellencies, the respondents have argued that the mere fact that the corruption violations occurred before depositing the optional declaration, the court does not have temporal jurisdiction. Your Excellencies, this is not the case. This court has held, in the case of Kijiji Isiaga versus Tanzania, that the court would still retain temporal jurisdiction where the violations are continuous in nature. And it is our submission that even though the corruption began before the respondent state deposited its optional declaration, its effects were still subsisting after the depositing of the optional declaration, and therefore this court has the continuous violation to hear the matter, contrary to what the applicant is making the court to believe.
Agent, respondent talk about instant violation vis-a-vis continuous violation. What is your reaction to that?
Your Excellencies, instantaneous violations, according to Nobezongo versus Burkina Faso, are those violations which occur finitely and therefore do not subsist after the state deposits its optional declaration. However, Your Excellencies, evidently from paragraph 14 and 13 of the facts, the illegal mining and corruption were still occurring after the respondent state deposited the optional declaration in 2019, and even to the extent that the respondent state has not remedied any of these violations, its effects are still subsisting, and therefore this court has the temporal jurisdiction to hear the matter. Third, Your Excellencies, the respondents have invoked the defense of necessity to justify their delay in paying compensation. However, Your Excellencies, for a state to invoke the defense of necessity under Article 25 of the ILC draft articles, it must be the only means to safeguard a state's essential security interests. And it is our submission that the state had other means to pay this compensation. Your Excellencies, the respondent states could have, based on Mr. Putin's conviction, and instituted a civil action in Sintefia to pierce the veil of the Adrix Limited to liquidate their assets of the company and use that to pay the compensation of the victims.
But agent, the doctrine of piercing the veil or lifting the veil, is it of universal applicability? There's no evidence that is applicable to the municipal law of Sintefia.
Your Excellencies, admittedly, it is not of universal applicability. However, it is mostly applicable in common law jurisdictions. And since from paragraph 1 of the fact and paragraph 4 of the fact, the respondent states is a common law jurisdiction, then it is our submission that the piercing of the veil principle would still apply to Sintefia. Fourth, Your Excellencies, the respondents have argued that the detention of the 20 GORA senior members was an administrative detention. However, Your Excellencies, even with administrative detentions, according to the UN Human Rights Committee General Comment number 35, specifically at paragraph 15, the states must still comply with the guarantees under Article 9. It is therefore our submission that for failing to still comply with the guarantees under Article 9, the state has still violated the GORA members' rights. Finally, Your Excellencies, the respondent states have invoked the margin of appreciation to justify their discrimination against the 20 GORA senior members. However, Your Excellencies, the African Commission in Prince versus South Africa has noted that inasmuch as the state has this discretion, it is not absolute, and the court has the jurisdiction to review the steps taken by the state, provided that they are inconsistent with the state's international obligations.
Sorry, President, I would like to know to what extent can you demonstrate to this court that this right can be limited in terms of mass appreciation? We know that this right is not absolute, but in facts, looking at the facts, how can you demonstrate and show this court that the state is hiding behind the margin of appreciation to not pass the legislation, to not pass the statute of the
Your Excellencies, if you could rephrase the question, agent did not understand.
When you were talking, you said that the right margin of appreciation is not absolute right, has a limitation. So my question is, how can you, based on the facts on the case, how can you demonstrate to this court that the state, despite the fact there's a margin of appreciation, the state can still, there's no argument that the state can use the tradition because it's not absolute. Looking at the facts, can you show us in the fact?
Your Excellency, is it your question that from the facts, could the state have ensured the enjoyment of this right without having to violate its values?
No. If you look at the facts, can you point us to evidence to suggest that under no circumstance should the state rely on traditional values to escape its human rights obligation, having regard to the peculiar circumstances of this case?
Your Excellencies, the facts do not indicate so. However, the African Commission's decision indicates that the state cannot use its margin of appreciation to merely limit the right where it is not justified. And Your Excellencies, it is our submission that the respondent state could have simply harmonized its values with its greater international obligation to protect the rights under the African Charter. They could have simply registered this organization and probably place fetters on the kind of information that they put out so as to protect their values, at the same time respecting the freedom of association of these CSMR members. It is on these grounds that we submit that the refusal was unjustified by failing to explore this option.
Right.
The applicants therefore praise this court to grant all the reliefs prayed and reparations. Respectfully submitted.
Right. So the bench will
recess briefly to deliberate, and then we'll come back.
Hello. All right, can I have your attention, please? Can I have your attention? Can I please have your attention? All right, as we're taking the deliberation, we'll be sharing some certificates. But before we do, can we all be seated? I think we've done a bit of stretch. That's good. We'll use this time to take a cultural performance, after which, just to, break the monotony of speech a little bit. When we come back, we'll take some certificates. So please give a round of applause to the CCAST as they entertain us with some cultural music. All right. All right, so I'll just explain the very first dance. It's called the Pacha, and it's from the Greater Accra region of Ghana, where we have the capital city, Accra. So that's Pacha. Now we're going to take the second dance that's from the Central region, and this is called Apatampa. It's from the Central region of Ghana, so please enjoy the Apatampa. Well, our dancers will be here very soon. Our dancers will be here very soon, but we are taking volunteers. Any volunteers? Do we have any volunteers as we get ready for our dancers? As the music is playing, we'd like to take some volunteers. I can make suggestions. Can I try? Can I call by name? All right. Sit by the bell. Enjoy. Well, thank you very much to the CCAS band. A round of applause one more time. All right, I think you had a fusion of dance from the south. That was the Upper Tampa. And of course, you saw a fusion of dance also from the north. Let me explain the bra. I think it's the elephant in the room. It's a costume for the dance called Bamaya in the northern region. So a long time ago, there was famine, and they realized the gods listened to the women more. Unfortunately, the women were famished and they were dying. So the men wore their costumes, including their bras, to go pray for rain. And it did rain. So that's why you see the men dancing Bamaya wearing the bra. So are we uncomfortable now? I hope we are less comfortable, so that's cool. Thank you very much. A round of applause one more time for them. All right, so let's take some certificates. I think the judges are still deliberating, so we'll fill that space by calling. Can I have some of the organizers here join me? Are we ready to distribute the certificates? All right, you can use the mic there. All right.
Hello? Okay. Good afternoon, everyone. I think a round of applause for the finalists for such an amazing round. And also, this is just an opportunity to acknowledge your efforts, because hours and hours went into preparing for this Moot, and without every single team that came today, we wouldn't have been able to have a Moot. So a round of applause for everyone. So we'll call out as per universities, and then a representative can come up from the team and collect their certificates. You can clap every 3 or so, not every after one university. University of Botswana. Haramaya University. Hildana. Okay, that's fine. Thank you.
Diridawa University.
No, no.
Diridawa.
There we go. Haramaya. KNUST. Gimpa. Wisconsin. University of Cape Coast. University of Ghana. Kenyatta. University of Nairobi. Kabarak. Obafemi. Ambrose Ali. Kabarak. Okay. Thank you. University of Ilorin. Unilag. Unilag, University of Lagos. Ebonyi State, Bayero University, I think this one.
Namdi Azukiwe.
Yes. Namdi. Okay, great. Forabe. UNISA, University of South Africa, Rhodes, Stellenbosch, Nelson Mandela, Western Cape, Fort Hare, Tux, UCT, Free State, Univen, VIT, UJ, Makerere, Lusaka, University of Zimbabwe, Midland State University,
Banfora from Burkina Faso.
Thomas Sankara, oh, no. Institut de droit international.
Excuse our friend.
And it's written in shorthand. Sorry. Université catholique de Bukavu. Bukavu, maybe? Swiss, UMEF. Oui, c'est ça. Merci. Peloforo, Côte d'Ivoire. Félix. There's only one. Billy? You'll teach me. Félix. Oui. Institut National Polytechnique, Côte d'Ivoire. Institut universitaire d'Abidjan. Universidad Eduardo Mondlane. The who? Okay. Institut Supérieur des Sciences de Mozambique. So much. Thank you so much, everyone, and congratulations for your participation. Please note that There are still some prizes that you're eligible for, so please stay around. It's important that you be here for all the other announcements.
All right, thank you very much. Okay, so as we still wait for the judges to return from their deliberation, let's take another performance. That's Bobobo from the Volta region. To all our guests, since you joined us last week, we wish we were able to take you around the country, but we're hoping just these dances gave you a feel of Ghana, right from the north to the south, to the east, and then to the west now with the Bobobo. All right, so they're here, the drummers are here. We're still waiting for the judges to return. We have some time to spare. Anybody want to stretch their legs? Now I'm asking actually for volunteers. So can we have some music? Just for the fun of it. Joanne, can I have somebody who would help teach? Joanne. Yes, please come. Wow. Okay. A round of applause, come on. So first of all, everybody is asking, who is the gentleman in the blue suit? Say hello. Yeah, the leader. Hello. The one who was leading the dance. Hello. Which country are you from? Côte d'Ivoire. Another honorable acknowledgement, a round of applause to our respondent from Burkina Faso. Also did amazing, thank you so much. And I can see we're all very poised for tonight's gala dinner. Are you ready for tonight's gala dinner? Was that just rehearsal? Are we to see more dancing during the gala dinner? There will be more music, of course, there will be more food. So make sure you're coming with your dancing feet. Don't leave it at home. Well, let's acknowledge some of our management members who have joined us. I can see the provost for the College of Humanities and Social Sciences, Professor Charles Marfo. Please give us a wave. Thank you so much for being here. I can see the Dean for Quality Assurance, Prof. J.J. Ponyo. Hello. Thank you so much for being here. Of course, I can see the Dean for the Law Faculty, Dr. Chris. Thank you very, very much. All right, we're going to wait for the judges as they deliberate. Please remain seated or just stretch a little bit. I'll come back and make the appropriate announcement when they are done with their deliberation. Thank you very much.
yari yari ekumbo etamusango mofetimbinde yana vilapa engingila yengeri badi ganto bangan bela bugambabo ibumori ni tumbata kema badi so songo batao ya musuku baboli boma sende di no Mbango Zaire na tena Congo na sibila Rwanda mutaka mwende mono Jemo ya bienwenji, jemo ya businga Mota moto wase mpina nyedenya ipo Olongo mbembe no ndutu Bela makuku ya senga Ke osi mende jene Neni la wano di pomane Tobanja bato pibone punya Babu seso wasa milomba Gumabilana titi bongo Osimende kakamba Usinga oka kiten Epoite na malanda Wele ya senda Mende yeno Sina malati Bakujen Ina malok Bakujen Namo ya singa Sina malati Bakujen Ina malok Bakujen Wileo ya senga Eima senga bunbambu Ngamusango bunyapone Imende jene Sesa wenge Mo Afrika Esele so Yepola Ilane bani Odangwa mbusa ndosibi weni omalano mbadonde londolende boso dititi mbusa tobia weni omalangwa nona ninbo wango nyendembo wasumo bongwa somo nanginye amuna ndende moyo wendo jomba ninbo wango nyendembo sumo wapepo wasomo nangi e amuna ndenge moyo wemba singala mwe autendande mola longe mole de ulondo pala mole manu singala ndo autendande mola longe mole de ulondo pala ebolo mabo masoro ndabo ndekembia me jingelo wa Bepete so moto nubilonge ke wabongwa mbia mongo lo nimbo wango nyende mbo wasupo wapebo wasomo nanginye ya muna ndenge moyo we ujumbawo nimbo wango nyende mbo wasupo wapebo wasomo nanginye ya muna ndenge moyo we wiye nanginya tembande alola lunge mole de ulondo kwala Emmanuel sengalando autendande mola lunge mole de ulondo kwala na dini ya motunge tomoto atiti sangwa masuki mutom selambo Mona tete ndutu mapatu be te ana wenge Titi tolambo ain't nobody yakata oh ain't nobody yakata oh ain't nobody yakata oh now dini ya motunge tomoto atitindabo sangwa masoki moto selambo Una tete ndutu mapatu be te ana wenge Titi tolambo ain't nobody ain't nobody ain't nobody Kote mola tobunya mona sweet Mary mama Mary where is mama mambo malonge monika mune kunisalinda na malaje tu bale na matimba jetu na malaje tu bale na matimba jetu bale Tuna bana bongo wenge batimbi wolowa batimbi tudamila ike Nakom nambia mwese wenge ulinganewa selambo bobe weke Uwa kuna malila jetu ubale Na matimba jetu uba Na malila jetu ubale Odangwa musa ndosibi weni omalano balonde londolende boso dititi musa tobia weni omalangwa nomina nimbo wango nyendembo wasumo bombo wasomo nanginye amuna ndenge moyo wendu tumba nimbo wango nyendembo wa sumo wape bowa somo nangi ya munandenge moyo wemba singa lambu outing bande mola longe mole de ulondo pala mole manu singa lambu outing bande mola longe mole de ulondo pala Ebolo ma boy ma solo ndabo ndeke mbia me jingelo wa lo Obepete so moto nubilonge ke wabongwa mbia mongo lo Nimbo wango nyende mbo wasupo wape bongwa somo nanginye ya muna ndenge moyo we utumbawo Nyenden bo wasumo wape bongwa somo nanginye ya muna ndenge moyo ele wiye nanginya tembande alola lunge mole de ulondo kwala Emmanuel o sengalambo tembande mola lunge mole de ulondo kwala Na dini ya notunge tomoto atiti Sangwa masoki mutom sela mo Una tete ndutue mapatu be Te ana wenge Titi to lambo In nobody yakata oh In nobody yakata oh In nobody yakata oh Now dini ya no tunge tomoto atiti ndabo Sangwa masoki motom selambo Una tete ndutu emabadu endu Te ana wenge Ojiti to lambo In nobody In nobody In nobody Kote mola kobunya mongamba Sweet Mary Mama Mary Weli Sane Mama Mambo malonge monika Mune kunisalinda Namala jeju Mbambe Namatimba jeju Namala jeju Mbale Namatimba jeju Mbale Tuna bana bongo wenge Batimbi wolowa Batimbi tubamila ije Nakom nambia mwese wenge Mulingane Sela mbogo beni weke Namala jeju Mbale Namatimba jeju Namala jeju Mbale Ayo ena nubiana Unyenge mwe otumba Okiloye wakakimba dibato Mondene no sambanga ndoninka Ayo kukunga wasenga Unyenge mwapa moto Mami nyanga tingemba musoka Mondene no sikanga ndoninka Umana mwana mwana Wamsena mala Umana mwana mwana Wamsena mala Tona tuwe Luwete pupa Munokote mwe munyengena Umana mwana mwana nona Wamsena mala sunwe jine komwa bobe esima kwa nyeke ndeke wonye mangando imangolo ayo ena nubiana unyenge me otunga ukilo e akatimba dibato mondene nonu kwangando ninka ukueleo ngalasenga namawolo pondwambo epabi wanga katimba musuka.
All rise.
So having heard robust arguments on both sides, before final verdict will be rendered, because as part of the game, there must be a winner. Otherwise, there wouldn't have been a need for us to prefer one to the other. But that is how the game is. And before we get there, the most important dimension of the exercise is what we are going to do to give you feedback from the benches and adjudication perspective, so that our feedback will provide some learning opportunities for us in the future. So before I will do mine, I will yield to my colleagues, and when they are done, then I will sum up and give my feedback. But before I come to the feedback, because the Honorable Chief Justice of the Republic of Ghana was the one who was supposed to have presided, I once again carry felicitations to you, and she is happy that the issue of corruption is part of the problem, which was argued in this year's Moot problem. And she would like the students, the law students, to work towards ethical leadership. And ethical leadership in the various endeavors you will pursue in foreseeable future post your legal education has to start with how you approach your current legal education. So the values of honesty, hard work, and diligence are encouraged. And her leadership would like to remind you to take lessons with respect to these values, which are to be distilled from the Moot program that you have argued serious, so that it will positively impact on your future career in various ways that you use your legal knowledge as lawyers, judges, politicians, academics, and so on and so forth. So her leadership wish all of you very well. So I will now come back to the feedback session. So I'll start from my left. The judge to my extreme left will give a feedback. And when she's done, the next judge to her, and then I'll go to my extreme right in that order.
Chers étudiants, congrats, félicitations, enhorabuena, dans plusieurs langues. Alors je vais vous dire très sincèrement, vous regardant dans les yeux les uns les autres, c'est important le regard, que je suis immensément fière de vos performances. Vous êtes une fierté à vous tous. Ce que vous avez réalisé est absolument exceptionnel. Pourquoi? J'ai été frappée, épatée par votre professionnalisme. Vous êtes tous très professionnels, vous avez gardé votre calme, vous avez gardé vos sourires, vous avez gardé votre maîtrise pour répondre à des questions qui étaient très déstabilisantes pour certaines, très déstabilisantes. Donc votre professionnalisme qui découle de votre très dur travail pendant ces dernières semaines a brillé aujourd'hui. Et je rentrerai en France très émue pour dire à quel point en Afrique, les jeunes étudiants sont extraordinaires. Et je le dirai à mes étudiants français et ceux d'Europe qui sont à l'université Paris 1 Panthéon-Sorbonne. Donc moi, je voulais commencer par vous dire que j'ai été très émue et époustouflée par vos performances, qui sont, je le répète, le résultat de votre travail. Donc en réalité, s'il y a une chose aussi à retenir, c'est que dans la vie, le travail est clé. C'est ça qui permet d'avancer. J'ai été aussi frappée par la ténacité qui vous a tous caractérisés, tous très tenaces dans la défense de vos points de vue. Et parfois, c'était assez difficile de défendre certains points de vue. Mais vous l'avez fait aussi avec beaucoup de professionnalisme. Alors, là aussi où j'étais admirative, et là c'est un conseil pour l'avenir, vous avez été amenés à travailler entre vous dans des équipes bilingues tout au long de la semaine, d'accord? Cultivez le bilinguisme ou le trilinguisme. Que les anglophones aient été heureux de rencontrer des lusophones et des francophones, qu'ils fassent l'effort d'apprendre les langues, le français, le portugais. Et que les Français et les Portugais fassent aussi l'effort d'apprendre l'anglais. C'est cela qui va vous réunir dans l'avenir. Parce que là, cette année, vous avez constitué en fait un formidable réseau d'amis. Vous avez découvert des amis de tous les pays africains. Vous avez dû être très fiers d'ailleurs de découvrir la culture des uns et des autres et la langue des uns et des autres. Continuez sur cette voie et apprenez à fond les langues étrangères. C'est un immense conseil parce que vous ne savez pas de quoi sera fait votre avenir, je l'espère et je le vois brillant. Mais pour communiquer entre Africains et puis pour communiquer avec le monde, maîtriser plusieurs langues est exceptionnel. Donc je vous encourage à maintenir tous les contacts merveilleux que vous avez eus pendant cette semaine si merveilleuse, très fort, cette semaine forte en émotion, et pour être soit bilingue, soit trilingue. Vous allez voir, votre vie professionnelle en sera absolument magnifiée, vraiment magnifiée. Parce que maîtriser des langues étrangères, ça vous ouvre le monde, ça vous ouvre les portes. Alors évidemment, les anglophones, ils maîtrisent déjà la langue commune du monde. Alors souvent, malheureusement, ils ne font pas l'effort d'aller vers les autres. Je les incite fortement à apprendre le français ou le portugais. Et j'incite fortement nos amis francophones à faire de même pour l'anglais, parce que comme ça leur permettra vraiment d'être très à l'aise dans ce monde où l'anglais prédomine. Alors, quelques remarques, mais vraiment afin de vous donner quelques conseils, mais j'ai le sentiment qu'il n'y en a pas vraiment à vous donner, parce que tellement vous avez été impressionnant. Ce que je peux constater, que le petit défaut plus ou moins général, mais vraiment qui est un défaut que j'ai cherché hein, pour vous dire quelque chose, c'est que quand on vous pose des questions, c'est pas facile, hein. C'est pas facile parce qu'on est déstabilisé et tout ce qu'on a appris peut être mis à mal, la logique qui était la vôtre. Alors certains ont très bien rebondi et ont oublié leur agenda, leur schéma d'analyse pour vraiment répondre aux questions. Et là, chapeau, parce que c'était un plus. D'autres ont gentiment fait des pas de côté pour éviter de répondre à la question. Et ça s'est vu, ça s'est entendu. Donc, s'il y avait un conseil que je peux donner, mais c'est pas facile, hein, c'est vraiment jouer le jeu, répondez à la question, essayez d'être impeccable là-dessus. Bon, voilà. Ce que je voulais aussi dire, et là aussi j'ai été époustouflée, votre capacité oratoire, c'est-à-dire que les uns et les autres, vous avez parlé sans notes, vous avez tout assimilé. Et ça aussi c'est le travail qui explique. Alors continuez, vous n'avez pas fait d'effet de manche, pas trop, hein, les effets de manche où on parle de façon un peu grandiloquente, c'est pas mal, continuez sur cette voie, soyez humble sur la manière de parler, il vaut mieux la technicité et la clarté. Ce qui vous a globalement tous caractérisé, technicité, clarté. Les effets de manche, où on veut être grandiloquent, peuvent amoindrir le fond. Or, ce qui compte, hein, quand on est un juriste, c'est le fond. Mais j'avoue que j'ai aussi énormément apprécié quand, parfois avec humour ou avec passion, vous avez transmis vos idées. Donc, la passion, ce n'est pas la grandiloquence, c'est deux choses différentes. Donc, privilégiez la passion à la grandiloquence. Voilà. Vous voyez, je n'ai pas eu beaucoup de critiques à vous faire, parce que je suis assez admirative. Alors, continuez sur cette voie. Si vous continuez sur cette voie avec le travail qui a caractérisé vos interventions, je peux vous assurer que tout ira bien. Encore félicitations.
Well, thank you. So, Judge to my immediate left.
Good afternoon, everyone. Apologize firstly because I'm a native speaker of Portuguese and perhaps my English is not the best, but I believe everyone can hear. First of all, I would like to thank all the students who came here in Kumasi and develop this amazing activity of human rights. Almost 2,000 years ago, I was there. And today, almost 20 years, I was invited to be one of president of this final. So I believe in 10 or 20 years, one of you or all of you come also here because this meaning you have improved your skills in human rights fields. When I see this final, I believe we have very young in Africa that we can be proud, because you are so talented, confident, and are trying always to improve your skills. That is a good example that the youth and the youngs in Africa are very talented. And I'm very proud what you have done here in these competitions. So I ask to everyone to try to improve all days. Regarding the case, I just like to give some advice for you. The first advice is try to use the general comment of the articles. Even the commission and the committee have made very general comment that help us to understand the meaning of one article. Also, I would like to advise to study also the continental studies, and we have many continental studies developed by the African Commission of People Rights and the Committee of Children's Rights. And these general commenters and studies can support you. One of the things that I didn't hear in these competitions, for example, is the study that the African Union guidelines to return, the safe return from children. I didn't hear any mention the work that the Committee of Children's Rights did about the COVID-19 and the guideline for the safe return to children to the schools. And when we try to defend something, we have to have a wide research. You have to look for everything that can be support for your defense. And this is what I would recommend for all the teams. For general, and to finish my, I would like to, most important to participate in this kind of activity, we need to be someone which makes change in the life. Human rights is protect human dignity. And it's very important, we have also the commitment to support the other people, empathy. This competition only will be a winner for us if each one of these students go to these countries and being someone who protects human rights, making difference, using what you have learned here to support the people. This is my advice, and thank you for how.
Thank you. So we take comments from the judge to my extreme right.
Thank you, Judge. Good afternoon, everyone. And I was really impressed with the quality of our students. They displayed good communication skill and good eye contact throughout the case without even staring at the paper. That's a quality, and I need to highlight that. And all of you, you showed that you have a great potential to becoming successful international lawyer. defending human rights case. You also impressed me with the quality of jurisprudence that you were able to rely on and to give the quick response to the bench, which is a virtue. And I want to make and highlight some of the things which I did not get much. It's related with the evidence. We as a lawyer, we know that we need to rely on evidence to make our argument go forward. And not just in the evidence, but the quality of evidence and how this evidence is collected and how it's can be brought to the court and how we presented the evidence and to see the weight of this evidence to being presented. In real life, I believe this is what normally we do as a lawyer. And this international opportunity is not so important just to build the knowledge, but also to have a cultural diversity and to be exposed to different people and build a network of different students from different countries in order to understand that we as Africa, we have a cultural diversity. And I know that there is a language barrier which most of the time undermine a cooperation among us. But we as African continent, we are diverse and rich in culture. And I strongly encourage people who want to pursue the career in human rights to also learn another language. For instance, myself, I speak my native language. My country language is Portuguese. But I managed to speak English. Maybe I'll try to learn a bit of French. I believe that this is important for someone who wants to work in an international environment. This is my advice for you guys. And I was impressed by the students from different backgrounds. The ones who speak French could have the capacity to articulate and to have coordinated moves without any distraction. That's a skill on its own. That is very important. And I believe we also need to encourage the Portuguese speaking teams for also to learn either English or French or learn both languages in order to be in the same level and to gain the space in the continent. Because I believe if we can do that, we can build a meaningful panel of experts which we can rely on each other and support each other in order to move forward. And it's also important, this exercise, because we have a different legal system. We have common law systems, Roman Dutch system is also this combination, and we from civil law system, we can learn more from common law system and other way around. And also to get a good reference and improvement as we move along when we cooperate among ourselves. And another distinctive feature that I want to mention here is that you were a good team player, both teams. They know how to play, but in terms of rhetoric, some of them, they did not adjust the tune of voice. At some point, they just raise a voice. This is something which is very important to give consistency, and you need to have time to breathe and to speak clearly in order to convey your message very clearly and to have a good, I don't know, I'm not finding the word in English, to be audible, to make the judge to understand it clearly, what you try to convey. And there is also importance in the sense that some of you were so good that it was very difficult for the judge to pose this question because we are very articulate and very clear on your explanation. That is also it's my appreciation. I show appreciation for that. And in real world, it's real tough to work in the area of human rights, but it's not possible. We need to be strong, and we need to have a strategy in order to find within our legal system, domestic legal system, the venues that we can take and be creative in order to bring forward the case of human rights. Especially in our country, the country our country like Mozambique, we Lusophone, we rely mainly or primarily in domestic law, domestic system law, and we do not rely much in human rights. And I think this is a challenge on its own. By this training is also bringing us the possibility for some of us who wants to work in the field of human rights can try to test the system within the country, just to also to educate the judges of the judges that are in exercise and the judge generation years to come, for them to understand the importance of human rights. Some people might think that this is an utopia, but this is a reality. We need to move, and we know that the change takes time, and we need to be persistent, we need to be consistent, and we need to be strong. That's my advice. Thank you.
Thank you very much. So, Judge, to my immediate right.
Okay, thank you, President. I will speak in French, but I will just say that I will not be long, since I have a flight at 5:30, and I could not find the cell phone of the pilot to ask him to wait for me. So I will not be long. Mais plus sérieusement, mes collègues ont déjà exprimé l'essentiel des observations qu'on pouvait vous faire. Et donc, je ne serai pas long, je dirais simplement qu'on a assisté vraiment à une audience, j'allais dire de haut calibre, dans la mesure où vous avez été très professionnel. Je me suis cru en tout cas en face d'avocats, de professionnels, et vraiment ça a été vraiment impressionnant. Impressionnant dans la spontanéité de vos réponses, dans la précision aussi dans votre argumentation, dans la maîtrise que vous aviez des faits, de la jurisprudence, mais également et surtout dans votre sérénité, dans votre calme, dans la posture que vous avez adoptée, n'est-ce pas, devant cette cour. Et pour moi, aujourd'hui, le gagnant, c'est l'expérience que vous avez acquise, que vous venez de nourrir à travers cet exercice. Vous savez, c'est souvent compliqué de décider quand vous êtes juge, parce qu'il y a des décisions qui vous donnent, j'allais dire, un arrière-goût. Pas parce que ce n'est pas juste ou ce n'est pas mérité, mais parce que souvent c'est difficile. Et quand vous arrivez à la maison, vous n'arrivez pas à dormir parce que vous avez l'impression qu'il y a quelque chose qui ne va pas ou qui devait être un peu plus juste et tout ça. Donc souvent c'est difficile. Et aujourd'hui, effectivement, il était difficile de vous départager, tellement vous avez été à la hauteur, à égal mérite. Mais il faut déterminer un gagnant et pas un perdant, mais un vice-gagnant, je dirais. Voilà, donc vous avez été à la hauteur vraiment à égale dimension. Vous nous avez impressionnés. Vraiment, c'est tout ce que je retiens, que ce soit le requérant ou le défendeur. Vraiment, je pense que vous avez de beaux jours devant vous et on ne peut que vous encourager vraiment à continuer, voilà, dans vos activités, dans vos projets pour l'avenir. Merci.
Thank you very much. So I stand on platform of all the feedbacks which my colleagues have rendered, just to add a few more points, and we yield to the auditor and organizers to take over before the verdict will be given. So first, those who know the Christof Heyns African Human Rights Movement competition, the original idea was to build human rights advocates for the African system, which had just started with the work of the Commission, Africa Commission, and later on the African court. Now that objective is still relevant. Few lawyers must use the African human rights system in domestic litigation. So that is the idea. And all of you here as law students, future lawyers, what you are learning and observing by participation in this competition throughout the week should not just end here. It must follow you into professional career, so that if you need to do anything human rights, don't limit yourself to just the Bill of Human Rights in your local constitution, but you must also make use of the knowledge, the rich jurisprudence, and the scholarly commentaries which have been generated around the African human rights system. And it is gratifying to know that if you look at our Supreme Court decisions and even to sometimes some High Court decisions, you see an effort of using some material from other African human rights systems or even from the general one at the UN level. And we need to do more. And that is why you as future lawyers, future legal academics and judges and all that, we would like to use this opportunity to encourage you to embrace that. That way, the purpose of the Christof Heyns All Africa Human Rights Movement competition will be realized, and it will not just remain an academic exercise. Having said that, mooting in general provides opportunity for students who embrace it to develop great intellectual skill, because you have to research, and those who have been participating in the mooting throughout the week will bear testimony to that before they could arrive at their arguments, they've done extensive research. And as you do research, you are acquiring very important skill, intellectual and also transferable skill, which you can deploy in your future careers and endeavors. So it is good that you chose to participate, because having been a teacher and a follower of mooting some years before going to the bench, I know how difficult it is to get students to participate in moot court competition, because some of them think that it's just a waste of time and just let me concentrate on my local models, examinations and all that. But I can tell you that you haven't wasted your time. You've acquired profound knowledge and appreciation of various areas of the law. And in terms of skills, you've also accumulated valuable skills which you would not have acquired easily had it not been your participation in this exercise. So you haven't wasted your time. As my colleagues have said, today's competition has been quite great. And let me say that whatever verdict will be given should not be taken too much at heart, to be too excited or to be too sad. And this is the explanation. We independently award marks as we hear you and observe. So that is very fresh, and we don't talk to one another regarding what I am giving or what he or she is giving. Then when it is done, we just put the figures raw as they are in the system program on the organizers, and whatever will come out will help us to pick a winner. And that is why I said that you don't have to be worried, but as my colleague just said, The most important victory is the experience, the learning, the participation, the networking, and all that you have actually lived throughout the week. The mark of a good advocate is the ability to think on their feet. And when I am presiding in mooting or any adjudication, I would like to engage advocates because that tests your understanding of the argument. It is very easy for argument to be cooked or prepared for you, and then we just master it and come and parrot it. But then the engagement with the bench and how you respond demonstrate your ability to think on the feet. And both sides, applicant, respondent, we've all demonstrated impressive skills in that regard. And I'd like to congratulate all of you and keep it up. So don't be worried when you are being engaged by the panel of judges. That is an opportunity for you to prove to them that you understand the law, you understand the facts, and you know what you are doing. And nobody has just prepared an argument for you to just come and rattle it around and go. And again, in terms of pace of argumentation, I would like to advise that you need to slow down the delivery. Sometimes I could see some of the advocates wanted to rush and then just get away so that they can move to another point. That is not it. You are timed, but if you are not able to carry all your prepared arguments, it's not necessarily going to affect how you be scored. Whatever you are able to do and the engagement and all that, that is what the judges will use to form their impression. So you need to take your time and then make your argument. So that is very important. And just before I leave, yes, my colleagues have touched on questions. Sometimes difficult questions are asked and you don't know how to go about it. And I also like what some of you did. If you don't understand the question, there's nothing wrong for you to politely ask the bench to restate it so that you understand it. Especially so in international competition or setting like this, where we have different tonation, different accent and all that. So it's not about the language and how nice you speak the English language or the French, but then the content and the skills which are more important. Yeah, so those are things I thought I should remind you. And again, I was also impressed with the use of logical reasoning. Some of you use logical reasoning in answering questions and sometimes using very impressive analogies. And that is something that you have to keep developing. I mean, on the whole, all of you have done very well, and Africa can only look forward to having great leaders. And just to reiterate what my boss said, that is her leadership, the Chief Justice, that you should make an effort. Don't give up on Africa. Don't say that nothing can be done. Corruption is a bigger problem across various countries in Africa. And that is why, as young people, and having regard to the Moot problem that you argued, we have to draw lessons from it and tell ourselves that we are not going to fall into those mistakes. So we are going to be the better future of Africa. So that is very important. So on that note, we'd like to congratulate all the teams and all participants. Thank you very much.
Thank you very much all for your patience. I think we can all attest to the fact that this competition this year was very intense and it was very tight. I just received a phone call whilst we were back there from Professor Franz Verleun, who would have loved to be here, but he was following proceedings online, and he actually said that the submissions by the teams today were excellent. So I think we need to congratulate the participants. And I think talking to the judges in the preliminary rounds, they were all quite impressed by the performances of the teams that appeared in the preliminary rounds. One of the judges actually stated that at some point he felt intimidated by the confidence and how articulate the students were, and that they believe that the future is bright for Africa in as far as building a vanguard of human rights advocates is concerned. Now, my job is easy today. I think you've been given very comprehensive feedback by the judges. Thank you so much. And also, the Center for Human Rights is accompanied by its leader, Professor Skuman, who is the Dean of the Faculty of Law, and she's going to make the closing remarks, so I don't have to say much. I am just here now to announce the recipients of the various awards in the preliminary rounds, and after that, I'm going to call on Jaco to then announce the winner of this final. We'll start first of all, and I'm going to ask the judges, each of the judges, to be ready to assist us with the presentations. Professor Lawrence, you are going to present the first awards that we are going to announce. So, the top French teams in the preliminary rounds, I'm just going to announce the top 4. At number 4 was Université Catholique de Bukavu, DRC. Number 3 was Université Peloforo Gon Coulibaly de Korogo. Then number 2 was Université Félix Houphouët-Boigny de Abidjan, Cocody. The top French team for this edition of the Christof Heyns Moot Court competition is Université Thomas Sankara. Then with Portuguese teams, the top French-Portuguese team is Universidade Eduardo Mondlane. The top English teams, I'm going to announce 10 of the teams that were in the top 10. At number 10 was University of Fort Hare. Number 9 was University of Ghana. Number 8 was University of Lusaka. Number 7 was University of the Cape Coast. Number 6, University of Nairobi. Number 5 was Makerere University. Number 4 was Kenyatta University. Wits University were 3rd. At number 2 was Kwame Nkrumah University of Science and Technology. And the top English team in the preliminary rounds was University of Cape Town. Now we are going to give awards for the top oralists and the top memorials. We'll start with the French-speaking oralists. And the top oralist will be given an award. At number 4 is Miante Yable. I don't know if she's here. At number 3 is Tegawende Davy Nakuma. Number 3 is Namijo Ange Olivier Louet. The top oralist and the winner in the French-speaking teams is from the University Thomas Sankara, Abdul Rashid Timtone. Judge Professor Lawrence to present. If you may come up, please, to accept your award. Abdul. For the Portuguese oralists, I will announce the top 2. And it was very difficult to separate between them. At number 2 was Ivania Mauricio Pene. The winner of, in the top, the winner of the Portuguese teams, who was the top oralist for this year, is from Universidad Eduardo Mondlane again. And that award goes to Almeida Nelson Muchanga. I'll ask Advocate Claudio for Kiko to present this award. The English-speaking teams, I'll just read out the top 10 oralists. At number 10 was Daula Mohammed from University of Cape Coast. Number 9 from Wits University, Kabelo Ramarumo. At number 8 from Makerere University, Harry Masija. At number 7 from Wits University, Batandwa Mtebele. At number 6 from Makerere University, Jamada Musa Kalinda. Number 5 from Kwame Nkrumah University of Science and Technology, Mame Ama Anan. At number 4 from University of Ilorin, Islamiat Oyandola Kolaole. At number 3 from University of Cape Town, Talita Wine. Now, I don't know if it's the first time, But this time around, for the English top oralist, the judges could not separate between the top two oralists. So we have a tie in the English speaking teams for the top oralists. The first one, I don't know if she's still around. If she's not around, her trophy will be delivered to her at a later stage. Rachel Weiss from University of Cape Town. I'll ask the judge president to present, to award the top oralist, the second top oralist with their shield. Judge President Dr. Dapa, if you may come over. So the second top oralist, as I said, there was a tie. The second one, who epitomized as well the qualities of a top advocate, calm, collected, and focused, goes to Mare Mulala from University of Lusaka. We'll now go to the memorials to announce the top memorials. The top Portuguese memorial, and I'll ask Dr. Wilson Adao to present this one. The best memorials in this Portuguese-speaking teams is from Universidad Eduardo Mondlane. You may come up to accept the award. Congratulations. Where's your teammate? Where's your teammate? Both. Thank you. Thank you. I'm going to announce the teams with the top 4 best memorials for the French. At number 4 is Université Thomas Sankara. At number 3, Centre Universitaire de Banfora. Number 2, Université Catholique de Bukavu. The top French memorial goes to the following team, and please, when you come forward with your teammates to accept the award. Université Numérique Sheikh Hamidou Kane from Senegal. They are not here today. They were unable to travel for the finals, but they're the best memorials for the French. Now we go to the English speaking teams. I will announce the top 10 memorials, starting with number 10, University of Lagos. Number 9, Uganda Christian University. Number 8, Stellenbosch University. Number 7, University of Fort Hare. Number 6, Wits University. Number 5, University of Nairobi. Number 4, University of Cape Town. Number 3, Kenyatta University. Number 2 was University of South Africa. And the best English memorial goes to the Kwame Nkrumah University of Science and Technology. I'm going to ask Dr. Suven Ore to come and present this award. Thank you very much. These were the awards in the preliminary rounds. I'll now hand over to Jaco to announce the winner and the runner-up for the final. Thank you so much.
Good afternoon. We knew after the preliminary round, the playoff rounds, to ascertain the teams for the final, that it was going to be very close because the determination of the teams for the final, there was less than 0.25% difference in their total scores. So we knew it was going to be very close, and certainly close it did turn out in the final, as you all witnessed. And I must apologize for the delay, for keeping you waiting, but it was that close that we had to check and recheck and make sure that our scores were right because it was extremely close. And the winner is the respondents, Sam and Kara and Kenyatta. And bad luck to the hosts in Nairobi. You put up a very good show. Well done. Congratulations to all.
Okay, so if you may sit, please. We are going to start with the runners-up to come and receive their shields together. Please, may the faculty reps also accompany them. Let's have these runners-up coming through to receive their awards. Thank you very much, applicants. If the faculty rep may also come, there's an award for the faculty rep as well, the team. I'll now call upon the winning team for this 32nd edition of the Christof Heyns to come and accept, together with your faculty reps. Congratulations to you all. Thank you very much. Okay, a picture for the team. Thank you very much. I'm going to hand over now to Professor Elsabe Skuman to make closing remarks, after which the judges have requested a photo of them at the bench, and also one photo of the judges and one photo of the judges with the participants for the final. Thank you.
Good afternoon, everybody. When it rained this morning, we knew that this was going to be a blessed day, and it surely was. My personal congratulations to the finalists, the winners, and the runners-up. Congratulations. This is a great day for you, and thank you so much for entertaining us with your excellent arguments. I was sitting there and I was thinking, you know, I'm old now, but when I was your age, I don't think I could have done what you did today. So, congratulations. I have a few thank yous to do, and I won't keep you long because I know that the proceedings has been carrying on for quite a while. But please allow me to thank our hosts. Our hosts have been wonderful. We've traveled from far and wide. We arrived here a wee bit tired. We arrived in these beautiful surroundings, this lovely campus, and also to your unwavering hospitality and generosity. I can't tell you how happy we were here this week. Every single person that we engaged with was accommodating, patient. Sometimes we change things at the very last minute. That is a nightmare for anyone organizing an event such as this. But we were always accommodated swiftly and efficiently. Thank you very much for that. And then I want to say that having created that atmosphere for us, it meant that we engaged with all the other participants, all the other faculty representatives. It made it so easy for us to engage. And that is really what this event is about. It is about engagement on human rights, spreading human rights across the continent, advancing scholarship, advancing education, and also just igniting that flame for human rights. We were able to do that this week because of the surroundings that we found ourselves in. Thank you very much to our hosts. I think we can say that this was a success on all levels. It was a great success. So congratulations to our hosts for having pulled this off in the way that they did. There are a few people that I want to thank specifically. You know, it's always difficult when you do thank yous because you don't want to leave anyone out. So there are just 4 or 5 people that I'm going to name. Of course, the first person, the Chancellor of the University, His Royal Majesty, Otumfuo Osai Tutu II, thank you very much for hosting us, for allowing us to be in this space for a whole week. To the Vice-Chancellor of the University, Professor Rita Dixon, she even made time in her very busy schedule to have a meeting with me, which was so much appreciated. You are fortunate to have a VC of her caliber, her energy, and so thank you also to her for hosting us this week. Then to the Provost of the College of Humanities and Social Sciences, Professor Charles Marfo, thank you so much. We were camping out right next to your office. The engine room, as I call it, of the Moot competition was right next to you, and it did not escape us that you actually stayed in the evenings till we left. And we are very sorry. We hope you can go home earlier this week. But that was very much appreciated, your kindness and generosity. Thank you so much. And then, of course, my colleague, the Dean of the Faculty of Law, Dr. Chris Adumaku Kwache. I hope I got that right, Kwache. We've become great friends, I think, and we already have plans for the future. Thank you very much for hosting us, also for running around and driving us around. Thank you very much. And then Abigail, where's Abigail? Abigail Anderson, thank you very much. We can't thank you enough for the great effort that you put in. And also the rest of the team, everybody who helped. I was asked to mention specifically the bailiffs. Everybody was very much impressed with the bailiffs. You've really raised the standard for this competition at this particular event this week. So thank you very much and congratulations on your professionalism. Then, of course, all the volunteers. Goodness, they were so well trained. It was a well-oiled machine. Whenever you were looking for something, there was a volunteer at hand. friendly, and always able to help. Because, you know, that's important. If you ask someone something, they have to be able to help you. And they were. Thank you very much. I can imagine the training that went into all of that. You put on a fantastic show. You've raised the bar, and I must say, I'm pleased that my university is not the next host. Then also, before I thank my team, the judges, you did the important, or you made the important decision today, which was not an easy one. So we really value your expertise, your experience. This was a very powerful bench. I met them all last night, and I went back to the guest house and I thought how privileged these finalists are to have judges of your caliber with real experience in this area of the law. Thank you very much for making yourselves available. We know that you all have very busy schedules. We appreciate that because we know that from you comes the inspiration for our finalists, for all the participants to work in this area so that they can see where they can go and also what influence they can have on the African continent. Thank you very much. And then to my own team from the Center for Human Rights at the University of Pretoria, I've decided not to name anyone because that's quite a big team and they've all worked very, very hard. When we're back in Pretoria, I will thank them appropriately. So for now, I'm just going to say the entire team, you have been fantastic. I was very fortunate, as I said, to be in the engine room to see how things are done. I can tell you it was chaotic on Monday morning, but everything was sorted. By midday, everything was running smoothly. Thank you very much. You've done a great job. Thank you. Lloyd, I hope I haven't left anyone out now, have I? Okay, then. I don't want to keep you any longer. I don't want to keep you in suspense any longer. But you know, this is the big reveal. Who is going to host this event next year? I see, unfortunately, the drummers are gone. You know, we needed a drum roll here. So it will be hosted by the University of Rwanda, and it will be in Kigali. Unfortunately, our colleagues from Rwanda has already left, but we wish them all. Oh, are you still? Oh. I didn't see you were still here. So we wish them all the very best, and we trust that this will also be an enriching experience for them. It is hard work, but you know, I spoke to your Deputy Dean the other night. You are all committed, you are on board, and we are very much looking forward to visiting your lovely country next year. So wishing you all the best for next year for this, this event. So I think we've come to the end of proceedings, Lloyd, is that correct? Are the judges still saying something? No? All done? So it just remains for me to thank everybody again for being here, for participating, for working hard to make this event such a big success. You know that it depends on the joint effort and also that positive attitude and can-do attitude from everybody to make such a success of this event. I know that there will still be a dinner tonight. Unfortunately, I also have to catch a plane later this afternoon, so enjoy the dinner, you can relax, you can unwind, and when you travel home, please travel safely and take good care. Thank you very much.
All right, so we'll take the pictures of the judges. Can we have the cameramen? First of all, we'll take only the judges, and then we'll have the respondents and the applicants join as well. So can we have for only the judges? All right, can we have the contestants join us? Can we have the respondents and the applicants join us? Please join the judges. Please join the judges. We're very deep in thought. I wonder why. Please join us. Join the judges, please. No, if you can just step up a bit, I think, yeah. All right. All right, so thank you so much, judges. Thank you so much. Thank you very, very much. Just a few quick announcements, and then we'll take leave of you. We're having lunch at Impact Building. It's served, so right from here, you can make your way to the Impact Building. We're having the dinner at Golden Bean. It starts at 6:30. That's for the gala dinner. We'll have the buses at Impact Building by 6. So please get ready, dress in your best. It doesn't matter if you took home a prize or not. Tonight is for you. Tonight is supposed to be the farewell gala dinner. So please come and let's all have a great time. If you don't mind, let's all be upstanding to have our distinguished dignitaries and invited guests take leave of us. Oh, we haven't said the closing prayer. Well, you are upstanding, so remain upstanding, and let's have Reverend Echampo do the closing prayer.
Please let us pray. Dear Lord, we continue to thank you for being part of us right from the beginning, being with us and ending this program successfully for us. We thank you for all the effort and all the resources that went into planning And we thank you that we can all say that it's been a great success. We thank you for all the experiences that we have had, students and staff and the judges and every participant here. We pray and commend ourselves to you, even as after this, we are preparing, various people are preparing to get back home. We pray your protection and your traveling mercies upon each and every one of us, that you take us safe and sound to our various destinations. We continue to bless your name for what you have done. Thank you for hearing us. In Jesus' name, amen.
All right, if you have the translation set, please leave it on your seat. All those with the translation set, please leave it on your seat. Leave it on your seat, but please do not leave. Let our dignitaries leave us before. Leave your translation set on your seat. Just place it on your seat. Place it on your seat. We'll come for them. Well, congratulations going out to you. Thank you very much. We'll see you this evening at the Golden Bean Hotel.